So, a wholehearted good morning to everyone. I hope our moderators and panelists are comfortably seated. I'm Ashwanshi. I'll be the session manager. In case of any technical difficulties, kindly contact me. I call upon our moderator of the session, Mr. Karthik, Company Secretary and Treasurer, ICSI Hyderabad chapter, to be starting the session. I'll be reiterating the structure once again. We'll have our opening discussion by one of our panelists, then the three paper presentations, and then the concluding remarks by our other panelists.
Thank you, Ashwanshi. We move on to the second day technical session. And since before beginning, I now request Dr. Dayananda Murthy ji, please come onto the dais. I now request CS Funny, VST Company Secretary, to come forward presenting a sapling to our speaker. Thank you, sir. Yeah, I take this opportunity introducing Dr. Dayananda Murthy. He's an associate professor of law and DPIIT IPR chair professor at DSNLU, where he is also served as an registrar and director of academic affairs. He holds an LLM in commercial laws, and he's a PhD on copyright in digital media and a master's in foreign trade with prior teaching experience at GNLU, the National Judicial Academy, and ICFI. He has co-authored various books, published research, contributed to legislative drafting in Gujarat and Andhra Pradesh, organized international workshops in Paris and Singapore, and served as a resource person and judge at leading academic and professional forums. With this, I welcome you, sir. Thank you for coming here. And I now hand over to you, sir, for your opening remarks. Thank you.
Very good morning. Thank you, sir, for the invitation. I thank Nalsar. I believe that when it comes to insolvency law, it's still an infant, right? I believe that having not even a decade of its life, we have still to learn many things. We have to see that how exactly we'll take the side of the creditors, what's the side of the financial creditors, what will be the fate of the operational creditors, within operational creditors, what are the classifications which you have to look into, right? And then what is the role of a regulator? I believe we have seen how the IBBI and the National Company Law Tribunals are striving to see that the time-bound resolution process has been taken up. Unfortunately, because of various reasons, the time-bound resolution process is yet to take up the gear, right? I believe that almost 65% of the cases have crossed the line of 270 days, and that's that we are still to improve upon the administration of the insolvency process in this case. And similarly, we have a lot of developments happening on that line. If you start with the liability of a personal guarantors under the insolvency law, I think we moved forward in that case, wherein in the SBI versus Ramakrishna case, we have identified that the personal guarantors can be made liable at any stage. That's a positive thing, which ultimately led to the amendment of the insolvency law. I think probably at the initial stages of insolvency law, we got the amendment to see the personal guarantors can be made liable irrespective of the moratorium which can be granted under Section 14 of the insolvency law. I think that's one part of it. And you all know that, I think many of you may be knowing that it all started with the constitutionality of IBC itself being challenged for the reason that the classification of financial creditors and the operational creditors were made. The operational creditors were challenging that it's violation of Article 14 of the Constitution of India for the reason that they have to undergo a process before directly coming into NCLT, which was permitted to the financial creditors. So under 7, the financial creditors can directly come to the NCLT, whereas the operational creditor have to undergo a process under Section 8, then comes under 9. So that was challenged. I think Swiss Ribbon answered saying that it is constitutional for certain reasons. I think the reasons are very clear. I think if you read the judgment, you will know that why financial creditors are treated separately compared to the operational creditors. This is one part of it. The second part of it is, once again, the time-bound resolution process. As I said, 270 days maximum period, 180 plus 90, which has been identified here. The SR Steel case clearly said how exactly the time-bound resolution process can derail in some circumstances. However, they said that once again an amendment was brought into IBC telling that 330 days was the maximum in that case. However, the SR Steel said 330 is directory, 270 is mandatory, 270 days is mandatory, whereas 330 is directory in nature, because it was speaking something about the legal disputes also to be done within 330 days. I believe it's impossible under the circumstances which we have in India, for the reason that every case probably reaches the Supreme Court at a point of time. So that's one of the reasons why it has been taken care of. And moratorium is once again an important point which the IBC has taken care of, including the SURFACE provisions get stayed. You cannot proceed under the SURFACE law. I think that's where I think there is a paper also on that line today, which we have to look into, that what are the complications between SURFACE law and IBC, right? And when IBC comes into play, automatically moratorium is granted. And that is how we have to see how exactly the law will coincide with not only the SURFACE law, including arbitration proceedings, right? Even arbitration proceedings can also be stayed under certain circumstances, which the insolvency law has to take care of. Then comes the resolution professionals and their responsibility. All the resolution professionals who are registered have a greater responsibility in this case of insolvency process, for the reason that they have to see that the information is collated as to the debts of the company, see that the information memorandum is identified, published, and see that a resolution plan is forthcoming. And this has to be done by a resolution professional at all time. Now, when you speak on this line, you can see what kind of challenges the resolution professional may have to face. We have seen where the resolution professional had to go to the police station, file an FIR for the reason that they were the threat on a person to go into the premises. We have seen that kind of cases also, where the resolution professional were not permitted to enter into the premises of a company. Various reasons, loyalty of the employees, they don't permit you to go there, right? So there are challenges for the resolution professionals. And we also seen the other side of it, where resolution professionals have not been performing better or involving in wrongdoings with the companies concerned there. So both the sides we have seen. The best of the things, the worst of the things we have seen here. Byju's is an example why resolution professionals were basically changed, right? I think you have all looked into that case specifically. That's one part of it which IBC has to look into. Then one of the highlight of IBC is your committee of creditors. Now the committee of creditors are said to be supreme. In the sense, once the committee of creditor decides that the resolution plan should be accepted or not, whether it should be rejected or not, right? It is their decision. It's a commercial wisdom of the committee of creditor, which is upheld by the Supreme Court from time to time. And NCLT has no role to reject the committee of creditors decision making in that case, because it's said to be a business decision basically, and wisdom of the creditors is upheld in all the circumstances. Once again, there is no guidelines. I think probably the government is now trying to bring the guidelines on how the committee of creditors have to work. I believe the best examples is your Shiva Industries case and Videocon Industries, where 95% of the haircut was permitted on a particular line, right? 95 is huge. You have a 64,000 debt. The Videocon case, they agreed to pay 2,500 crores, and it was accepted by the committee of creditors and ultimately approved by the Supreme Court of India. There, we have to see how exactly the committee of creditors role becomes important in that case, right? That's one part of it. So what are the guidelines? What are the rules relating to how a committee of creditors have to work is one of the things which I think is forthcoming. The government has already taken up the decision to frame rules for the committee of creditors. Probably in a 6 months or so, I think we may find a way on that line also. That's one part of IBC. The next part of IBC, I believe all of you know, is group insolvencies. When I speak of group insolvencies, many companies have their own subsidiary companies having businesses not only in India, outside India. And how do you deal with the group insolvency is a challenge. India is just framing the rules on that. Once again, we are a little bit delayed on that particular line as to group industry is concerned. The Supreme Court has taken note of it. Once again, Videocon case has answered how exactly the group insolvency can be taken up. Wherein all the 13 companies of Videocon were brought together and said how the assets and liabilities could be decided in a case of group insolvency as such. And I think the committee has already recommended what can be the law for the future. We'll look into how exactly it turns out to be the law, a better law for us in group companies concerned. The next major and the most important thing, I think I have seen the schedule. Many of them are dealing with cross-border insolvency, very challenging aspect of insolvency law. The reason is no country will accept my sovereignty over other sovereignty, right? That's the norm of international law, basically. So they have propounded some ideas of how exactly the cross-border insolvency law can be taken care of. Sir, how much time? Okay. We have seen how exactly the cross-border insolvency law has been taken up. Basically, we have three theories which have been developed under the cross-border insolvency. The first one is where you want one single unified procedure to be followed in that case, which we call it as universality principle there, where in one particular place where the company is registered, start the proceedings, then all the other countries will have to coincide with that particular proceeding, right? That's one thing which we speak of universalism coming into picture. The second one, as usual, municipal law, domestic law will have to play territoriality. That is where we speak of the domestic law will decide whether the insolvency should be considered outside the country as such. Okay. Now, how do you manage those things has been once again a question mark which we have to look into. And the last one is hybrid scenario. When I speak of a hybrid scenario, recently, I think 2025, the Singapore High Court has decided, I think for the first time, recognized the CIRP process of India in Singapore. I think that's the case which which is a highlight of accepting Indian jurisdiction in the Singapore jurisdiction. The High Court of Singapore has said that yes, the NCLT process is a quasi-judicial process. We accept, Singapore accepts that it is a process under insolvency, and said that all the assets in Singapore can be moratorium can be granted even in Singapore for that particular matter as to the assets of the company in Singapore. That's one thing. Second thing, major thing, the resolution professional who was appointed was considered recognized as a representative, a foreign representative in that particular case in Singapore, and he has a right to represent the company in India, in Singapore in this case. That's a major positive thing which Singapore courts have recognized. I think in that case it has been recognized basically as to how exactly a foreign country has recognized the national company law tribunals working as acceptable. And similarly, the representative, means the resolution professional being a international representative in Singapore, has been referred to in that particular case. I think it has been recognized basically. The only thing which Singapore court did not accept was actually the representative asked for taking all the assets back to India. Okay, I think repatriation of the assets to India. I think that has not been accepted for one reason. The reason is you have to give notice to the creditors in Singapore. Okay, after giving notice to the Singapore's creditors, then you take up the matter. I think then you can repatriate the things. So a right of hearing to the creditors of Singapore was given in that particular case. And ultimately, I think we are moving in the positive direction when it comes to the cross-border insolvency in that case. Means the Indian law and the IBC has been recognized in a foreign country, bringing in a hybrid kind of scenario here. See, I told universalism, territorialism, and then the hybrid scenario. The hybrid scenario has been accepted by Singapore on that particular line. I think that's a positive sign for us, basically, right? That's one thing which has been taken care of. I think I'll not much speak on cross-border. I think there are many people to speak on that. We'll leave it there. Then ultimately, we all know there are 4 pillars in insolvency process. The first one is NCLT itself. The second one is the resolution professionals. Remember, they are the main pillar of your insolvency process. And then the third one being your committee of creditors. And one more most important thing is information utilities, where every information relating to the debtors are stored in electronic form in that case, which I think probably the earlier law did not have. So basically the information utilities are those cases like your CIBIL score, right? I know my company is registered there with the information utilities. I know what is the debt which I have to pay, what are the liabilities I have. So ultimately, if a creditor wants to know exactly what is the liability of a company concerned there, I'll go to information utilities, and that information will be enough for me to identify whether I should come with a resolution plan or not to come with a resolution plan, because the company is in doldrums. I cannot make the company survive at any cost. If the person coming out of the resolution plan finds that, probably the company may have to go to liquidation, right? I think that's the process which insolvency law has taken up in that case. So information utilities, when it comes to information utilities, one major thing which you have to look into here is, can we bring in artificial intelligence into storing information in this case? Now that's a challenge. I think there are two to three papers which they are presenting it. I leave it to them to present on that line as to how exactly AI with their algorithms can help the insolvency process in India in that case. I believe day before yesterday, we had an information very specifically by the end of December. I think artificial intelligence will be used by all the courts in India. I think that's the information which we have. Probably the National Company Law Tribunal may also get the AI performance or AI inputs into how exactly this can work out. So basically, to what extent the AI can help you is once again an important challenge. It's a challenge, real challenge, because when you look into AI is a facilitator. Please, I think we should understand that. AI is a facilitator for better performance. It cannot be a decider for us, correct? Na? That's the most important thing we have to look into, because ultimately what we have fed into the AI, we'll get the results based on that. So we have to be cautious enough what information should be taken, what information should be stored, what information really helps us to solve the insolvency process there. So AI will be the future. Now, what are the challenges which you have to look into in AI is once again an important point, which I believe that for the next 10 years, we'll see that how exactly AI will help us in resolving insolvency process, because you have fixed time of process being completed, right? AI may help you in that regard. Timeline can be done, including giving a warning to you that time is up, Mr. or Miss, please get ready, because 180 days is over. You have to do something better for your performance. So probably those kind of things can come up when it comes to the AI being used as a tool for our insolvency resolution process. That's one thing. The next thing is, once again, a very important point is your valuation of assets. We all know that when a company goes to insolvency process, we are speaking of maximization of value of the assets of the company, which is existing at that time, right? Now, how do you maximize the value of the assets? Once again, RP plays a very important role there. The resolution professional have to take charge of the assets and see that how the maximization takes place, considering all the stakeholders' interest there. Not only of the creditors of the company, of the suppliers, of the employees of the company. I think Sridhar case answered that, saying how classification of operational creditors has been made. I believe that people who are non-financial creditors versus suppliers as creditors. So they have classified it once again in Sridhar's case, wherein when it comes to a financial creditor, they are bankers and financial institutions. When it comes to a person who has given finance to the company, but he is not a financial creditor there, right? So that person has been classified once again with a supplier of the company who can be a creditor for the purpose of law. So that classification once again is to recognize all the stakeholders in the insolvency process there. Now, who has to be paid first? Probably they have to be paid first. So the waterfall mechanism will also be a challenge for us. I believe you all know that there is something called as a waterfall mechanism, normally applied in liquidation process, but how you will apply in CIRP process is a challenge, right? So who should be paid first? I think Reliance answered it, wherein the operational creditor were paid first when it comes to the committee of creditors being considered there, right? So basically, highlights of insolvency is, as I started with telling, we are still an infant when it comes to the insolvency process there. And to this extent, we are moving positively. Insolvency process is taken positively to us. I think that's a positive for us also to see how exactly we move forward with the insolvency process as such. That's one part of it. Coming to liquidation here, when it comes to liquidation part of it, I think we need not much speak on that, because we are trying to bring the company back into life rather than killing a company. So what we do is, when it comes to liquidation process, one of the major important point which has to be considered there is with reference to SURFACE versus insolvency law. Now, a company under section 52 of the insolvency law can decide, the creditor can decide either he steps into the shoes of the liquidator or stays outside the winding up proceedings and recover. So that's a challenge for you, right? So under 53, the waterfall mechanism is already scheduled. It's fixed. Who gets first? But when it comes to 52 says that if a creditor decides that he doesn't want to enter into the winding up proceedings, yes, he can decide. Now he stays outside the winding up proceedings. When he stays outside the winding up proceedings, now what are his challenges? Will he recover the amount which is due to him? Right? Will the creditor be able to balance the employee's rights in that particular scenario? So all these are once again challenges which we have to look into when it comes to the creditors in SURFACE law versus creditors in the insolvency process here. That's also a challenge for us when it comes to liquidation as such. And when it comes to liquidation, we all know why insolvency law was, I think I should come to history now. Why insolvency law was brought into picture? For the reason that the civil courts failed in the first instance, DRT failed in the second instance, even SURFACE failed. Yes, probably that's the reason why we got insolvency law into picture there, right? Wherein we followed the UNCITRAL model of insolvency law, bringing in the time-bound resolution process here. As NPA was growing hugely on that particular line, IBC had become a necessity for us. When you look into the historical perspective, I believe that we have done a better job in the last 9 years compared to what we had done from the 1947 or so. I'll not go before 1947, at least from 1947, what we have done, I think we have done in 9 years, specifically on that line. I think that's what I tell. We can take positive things from the insolvency law. I think the child needs some hand-holding from all of us as stakeholders. I believe everyone, if we take it on that line seriously, without any hindrance as such, or without any negativity on that particular point, I think insolvency law can actually be a successful venture here, right? That's one thing. The only fortunate thing is recently the appointments for NCLT has been completed, I believe. I think that's what the news says. I don't know really they are functional as such, because that was one of the major problem in solving insolvency process here. One of the reason is when IBC came into picture, probably they thought a separate NCLT kind of thing, because that's the reason they use the word adjudicating authority at that stage. However, they pushed the insolvency law into to the NCLT itself. I think that has caused a huge burden on the NCLT, because it's not only insolvency law cases they are hearing many other cases on company law. The whole of company law is regulated by the NCLT there, right? So that's one of the reason why the problem may come in when it comes to NCLT, and the number of benches which they have, how exactly they can perform is a question mark. I think to that extent, if all the functional NCLT works properly, I believe that's a positive thing once again. And one more recommendation has been made to deal with cross-border insolvency, to have a separate bench under the NCLT process. I think that's also one of the positive note which we can think of, where a separate bench for dealing with cross-border insolvency law is a positive thing for us, right? I think with these few words, I think time is up, right? So with these few words, I believe that we'll take the things forward, right? I also expect some of the presentations to be there. Here only, no, sir? Right, okay. All the best for your presentations. Whatever little knowledge we have, I think probably you can share with us. We will also share a little bit of knowledge we have here, okay? Thank you. Thank you for the opportunity given here. Thank you. Dhanyawad.
Thank you, sir, for your opening remarks. Highlighted the importance of 4 pillars of IBC, and also the evolution of IBC, how it's a game changer in the corporate world. Thank you, sir, for your opening remarks. And you have set the stage ready for our paper presenters. And before move on to our paper presenters, I request another panelist, CS Shailesh Baheti, to please come on to the dais. I now request CS Rajesh to come forward for presenting a sapling to the panelists. Thank you. Before we move on to the presentation of the papers, I have an instruction to share. Each presenter will give 15 minutes of time to present their paper, and author should highlight major findings in their paper. I now request Sorry, yeah. Sorry, I could. It's my sorry for I forgot to introduce. We have another panelist, CS Shailesh Bahati. He's a fellow company secretary, and he's an insolvency professional and founder partner of Bahati Gupta and Co. Company Secretaries, based out of Hyderabad, with over a decade of practice in corporate laws, SEBI compliances, restructuring, FEMA, and representing before NCLT, RBI, and other forums. And he is a frequent speaker at various forums, and he is a certified life and certified transformation coach. He leads the IRA Foundation, an NGO promoting inclusive education for underprivileged students. With this, I welcome you, sir. Thank you for accepting. Thank you. I now request Ashwanshi to take forward. Thank you.
So before calling our first presenters, I would like to know if the online people can hear me.
Yes, madam, I can hear you.
So before calling our first presenter, I would like to reiterate that the presenters have 10 minutes for their presentation and 5 minutes for Q&A. For offline presenters, I'll be showing time cards when the last 2 minutes are left and when the time is up. For online presenters, I'll be typing in the chat box. I now invite our first presenters, Ms. Prerna Sirvani and Mr. MP Ram Mohan.
Yeah. Good morning, everyone. Thank you for giving me the opportunity to present today on a topic that's increasingly relevant in India's financial ecosystem, crypto assets, or as how it's popularly and formally known in India, virtual digital assets or VDA. My paper is a foundational inquiry on the treatment of virtual digital asset service providers under the Indian insolvency framework. The research objectives are three. First, does India need to prepare for a crypto insolvency? Second, can crypto assets be considered as property and therefore be subject to a debt classification under the current IBC? Third, analysis of legal developments across the world with the aim of identifying key challenges and insights that India should consider in preparing its own legal framework. Now, the Indian government has made limited efforts to include crypto assets in Indian statutes, but those efforts are mainly for taxation and anti-money laundering compliances. India still lacks a comprehensive regime for crypto assets. And WazirX, as you would have popularly known, a crypto exchange that was hacked back in like July 2024, the users are still waiting for the recovery of those assets. So WazirX hack exposed certain regulatory gaps. What was WazirX? WazirX was a company incorporated in 2017 in India under the name Zanmai Labs Private Limited. In 2018, RBI issued a directive that banks can no longer facilitate cryptocurrency transactions for crypto exchanges. Agreed by this, WazirX founders incorporated a new entity in Singapore in 2019 and named it Zetai Private Limited and shifted the crypto operations from Zanmai India to Zetai Singapore. Zetai was also involved in an acquisition transaction with Binance, another crypto exchange, but that deal fell through. In 2024, WazirX suffered a major cyber attack that wiped out 230 million US dollars of crypto assets. Zetai, the WazirX entity in Singapore, filed for restructuring under the Singaporean insolvency law while continuing to dispute liability with Binance. Recently, Singapore law was amended, so now all the Singapore entities that provide crypto services outside Singapore, like how Zetai was providing services to Indian users, they're now required to obtain a license. WazirX did not obtain this license. What they did was went to Panama and incorporated a new entity. So what's happening? WazirX, an India-based crypto exchange, is engaging in cross-jurisdictional maneuvers like restructuring in Singapore, incorporation of a Panama entity against the backdrop of an ongoing ownership dispute with Binance, and Indian users continue to face prolonged uncertainty on when they'll get their crypto assets back. This is not unique to WazirX. Crypto platforms are known to engage in regulatory arbitrage by relocating to jurisdictions with favorable legal system, thereby complicating the determination of crucial elements in an insolvency, like the determination of applicable law, jurisdiction, and the very identity of the corporate debtor. Now, WazirX has a lot of users in India, so naturally users went to Indian judicial forums also, like Delhi High Court under writ jurisdiction and NCDRC under consumer law, stating that crypto assets that are not affected by the cyber hack should not be made part of the restructuring. But both the Indian courts dismissed the cases, saying that there are no regulations for us to be guided by. Currently, there are two ongoing cases in Delhi High Court, but Indian courts until now remain hesitant to adjudicate in crypto disputes due to lack of the available regulatory guidance. Now, crypto exchange is like any other company that can fail and go into insolvency, but we have assessed certain structural reasons why crypto exchanges are way more prone to failure than any other business. First is they are susceptible to a cyber attack. Now, crypto asset systems such as Bitcoin allow its users to conduct irreversible transactions with anonymity. Irreversibility, anonymity, both misused by cyber criminals. And once a platform's cybersecurity is breached, the recovery of misappropriated funds is highly improbable before those assets are laundered into white money. In India, the recent examples include WazirX and CoinDCX. The second structural issue is that they operate without any regulatory oversight because crypto regulation is in its nascent stage throughout the world. In 2022, in USA, a stablecoin project called Terra crashed after its crypto coin USD lost its value. The company did not have enough liquid reserves to support this crash. This led to the collapse of related firms like Three Arrow Capitals and Voyager, both crypto players, which had made unsecured loans and could never recover their losses. Because crypto entities operate with little regulation, they often take risky positions and partner with unstable players to offer extremely high returns, but they do not have reserves when things go under. Recognizing these risks, the European Union developed a law called Markets and Crypto Asset Regulation, or MiCAR, that enforces reserve requirements, asset segregation, and consumer protection mechanism. Similarly, in USA, there is a Genius Act that has been passed that mandates one-to-one reserves for stablecoin. Stablecoin is considered a crypto asset only. Now, crypto investing in India also needs a user protective platform. But before we go on to what law we can make and how it can be treated under IBC, the first critical issue that we need to deal with, can crypto qualify as property? Now, the courts in UK, Singapore, New Zealand, they have all held that crypto assets are a part of property. Under the Indian Insolvency and Bankruptcy Code 2016, the definition of property is broad and includes every description of property situated in India, outside India. So my contention is that the definitional scope of property in Indian IBC is sufficiently expansive to encompass crypto assets. Coming under debt classification, debt is mostly of two types, financial and operational. Now, financial debt is a debt that, along with interest, if any, which is disbursed against the consideration for the time value of money. Today, if you buy crypto assets, that does not mean that you will get a particular return after a particular amount of time. Any profit that you gain is solely based on market forces of demand and supply. So crypto asset buying cannot be considered a financial debt. Let's see if it can be considered operational debt. Now, under the Sale of Goods Act 1930, goods include all kind of movable property except two things, actionable claim and money. Now, one may argue that if crypto, like other jurisdictions have, is also considered as movable property in India, it can be considered as goods and therefore fall in the category of operational debt, that is claim in respect of the provision of goods or services. However, we must not lose sight of the fact that crypto was developed as a currency. It has a functional equivalence to money. And Supreme Court of India, while it removed the RBI ban on crypto asset, also said that crypto assets basically is intangible property that can act as money in under circumstances. Therefore, there may be issues, legal issues that can come if you categorize crypto as operational debt. So as we see it, under the current legal framework of the IBC, users of crypto exchanges are neither operational creditors nor financial creditors. How do we protect the crypto users? Under the IBC regime, there's two provisions that can help them. The third party assets that are in possession of the corporate debtor under trust or under contractual arrangement are not part of either the restructuring estate or the liquidation estate. But how do they claim rights over this? Because there's no statutory right. And the only contractual arrangement is when you say yes or click tick to their terms and conditions. So yes, read terms and conditions carefully, but these terms and conditions also are extremely long, complex, ambiguous, rife with internal inconsistencies, and subject to frequent and unilateral modifications by crypto exchanges. Therefore, the only way out is to create or adapt the existing law. In USA, in context of stable coins, the Genius Act provides that the claim of a stablecoin holder will have priority over the issuer's other claims in case of an insolvency. The other few issues where we see that statutory intervention can help, first is segregation. So crypto exchanges like FTX and Binance in USA have been accused of mixing the consumer assets and their own assets and then abusing them. The European Union has developed a law that requires that assets should be legally and operationally stored separately, the client assets and the exchanges assets. In Indian securities law also, a stockbroker cannot keep the securities of the clients and its own securities in the same account. Similar guidance should be made for crypto assets. Second suggestion is to adopt the unilateral model law on cross-border insolvency. Crypto insolvencies is often spans multiple countries because crypto is basically a digital ecosystem with debtors and creditors around the world. And frameworks like unilateral model law helps courts coordinate across borders. I'll just take 1 minute to wrap up. However, India has not adopted the unilateral model yet, and therefore it makes the international cooperation slow and challenging. The third is a valuation challenge. So crypto assets are highly price volatile. That makes their valuation very difficult. In India, currently the valuation is anchored to a fixed date called the insolvency commencement date. But crypto's price can increase or decrease dramatically, as has happened in insolvency cases outside India. And therefore, because the CIRP process in India is so prolonged, the suggestion is that the valuation method should adopt certain flexibility for crypto insolvencies if there's a dramatic price development. In conclusion, I'll say insolvency law applies to crypto exchanges just like any other company, but their structure, technology, and cross-border operations create unique challenges. Given the increasing crypto appetite in India, it's imperative that Insolvency and Bankruptcy Board considers developing specific regulation to address unique issues of crypto insolvency. Thank you. Are there any questions?
You spoke something about shifting of the assets, cryptocurrency from one jurisdiction to other jurisdiction,
yes.
right? Is it a choice of law or forum shopping?
It's forum shopping. But
Permitted.
not during the judicial process has started,
Right.
before that. So what these crypto companies do is they can see that a legal development is going to happen, the law is going to become stricter, and they move outside the country. So like how Singapore was saying that it will do license verification and licensing of crypto exchanges. So before it can bring that law, they got out of Singapore.
So is it wrongful to do that or rightful to do that?
It's wrongful to do that in terms of judicial challenge that it brings, because currently most of the users of WazirX are in India, but the restructuring is happening in Singapore. So the Indian users have no avenue to go. So from a user framework, it's not correct. But from the company framework, obviously, that's there because they're misusing that crypto law is nascent in some parts and not in some parts. Whereas in securities law, because most countries have developed securities law, you can't do forum shopping in such a way because every country will like hold you to its law.
Have you put the solution in this paper for this?
For the forum shopping,
Yes, yes, yes.
it's international cooperation. So currently OECD, FATF, they all are like collaborating on creating international
You have
framework.
discussed that in the paper?
Yeah, I have.
Right, okay. That's second one. When you speak of Section 2H of the SCRA Act, it defines securities.
Yes.
Last part of the definition says any other instrument.
Yes, it says.
So can we cover that cryptocurrency under that heading?
No, we cannot. I'll explain why. Because the whole definition of security is that security needs to be issued by an entity. In India, there is no concept of issuer independent. So a mutual fund can issue a security, a company can issue a security. Crypto, like Bitcoin, there is no issuer. An anonymous platform where you can sell and buy crypto. So there is no entity for like how share is like a liability of a company. A company can claim a share, but crypto is
No, my
insured.
point is whether the government can declare that as a instrument covered under securities.
Sir, it can, but then the whole element of issuer dependent security is gone out of the window.
Got it. Okay, thank you.
By you, crypto classifies as property under IBC. It's within the definition of property?
No, it's my suggestion that crypto should be classified as property because it cannot be categorized as security for the reason I said. Then the only way the users can be protected if a crypto exchange goes into insolvency is to first step is to categorize crypto as property, and because property definition is very wide, crypto can come under it.
So on your research, have you come across any such cases where a corporate debtor was holding a crypto and RP or liquidator has tried to take control of that crypto being part of the liquidation asset or
outside
estate?
India? Yes. In there was a case of New Zealand called Cryptopia, where ultimately crypto assets were considered as property. But for in that case, the reason it was considered property is so that the users can assert proprietary claim, so that the crypto assets are not made part of the liquidation estate.
See, one important challenge which you have raised is about definitely the valuation of the crypto.
Yes.
But have you also thrown the light on one more important aspect, because crypto can be held both offline and online?
Yes.
So that is the biggest challenge. If it is made a part of property also, the users or being a corporator, they have a even right to hold an offline mode.
Yes.
Where getting control through the crypto or over the asset will be very, very difficult. So that also should be thrown light in your research paper, where it is offline holding and where there will be no direct control on the administrator on the asset or the property.
Right. That comes under the theme of asset tracing. Because so for the audience, there's a way you can hold the crypto offline, so there is no online record of it. But in India now, there is an entity called FIU, in Financial Intelligence Unit, where basically it has mandated all the crypto exchanges to store records of who is buying crypto from them. So if these are registered crypto exchanges that users are buying and selling crypto on, then that entity will have a record. But obviously black market exists. So if that company goes, then we don't have anything. Thank you so much.
Now I call upon our second presenter for the day, Ms. Shalini Iyengar. Can you hear me, ma'am? You can also share your PPT on your
Yes, ma'am, I can hear you. Can you see the PPT? Is the PPT visible?
Yes, ma'am, your PPTs are visible.
Good morning, everybody. My name is CS Shalini Iyengar, and I'm presenting my research on harnessing artificial intelligence and data analytics in CIRP, opportunities and imperatives under IBC 2016. The research explores how AI can transform India's insolvency framework, drawing from empirical data and global best standards. We will cover the current challenges, AI application in CIRP implementation strategies, while preserving human oversight and professional judgment. Let us see how technology can make CIRP faster, fairer, and more efficient. Let me begin with some sobering statistics that reveal the magnitude of challenges we face today. The numbers tell a stark story. After 8 years of IBC implementation, we have 8308 corporate debtors admitted as on March 2025. However, the performance indicators paint a concerning picture. Like Mr. Murthy said, average resolution timelines have ballooned to 713 days, more than double the statutory 330-day limit. Financial creditor recovery rates have declined from 43% to 32% today. Operational creditor recovery remains stagnant at 25%. Nearly 2,000 cases remain ongoing beyond the mandated duration. 78% cases exceed the 270-day benchmark. The critical pain points are systemic. Manual claim verification processes consume weeks instead of days. Repetitive litigation creates endless delays. Limited transparency frustrates the stakeholders. Inefficient document management system burdens the resolution professionals with administrative overhead instead of strategic value creation. While India grapples with these challenges, other jurisdictions have pioneered transformative solutions that offer us a roadmap way forward. Colombia leads the world with its AI powered insolvency portal MI that has half the average case disposal timelines. The system employs biometric authentication, automated regulatory compliance checks, real time stakeholder dashboards accessible via mobile apps. Other noteworthy digitization initiatives include Portugal's CTS e-platform and Finland's COST system. Let me present the transformative economic impact that AI implementation can deliver, backed by concrete numbers and international precedents. Timeline improvements are substantial. Overall, CIRP duration can reduce to 400 days from 713 days. Claim verification can reduce to 6 to 8 days from 21 days. Plan evaluation can reduce from 37.5 days to 12.5 days. Recovery enhancement shows even greater promise. Financial creditor recovery could improve from 32 to 50% to 37% enhancement. Operational creditor recovery could rise to 40% from 25%. Total value realization as a result could increase by 40 to 50% through optimized processes. System-wide benefit includes reducing ongoing cases from 1926, which is an expected 40% reduction, improving NCLT disposal rate from 75% to 85 to 90%, increasing pre-admission settlements by an expected 15%. Let me demonstrate how intelligent automation can transform each stage of CIRP lifecycle with specific measurable improvements. First will be application filing. NLP-powered document processing with automated defect detection can reduce timelines from 30 to 45 days to just 7 to 10 days by screening applications, checking compliance, and extracting essential data automatically. Claim verification. Automated cross-database validation with fraud pattern recognition can shrink verification timeline from current 30 to 45 days to just 7 to 10 days by screening applications, checking compliance, and extracting essential data automatically. Information memorandum preparation, AI-driven data extraction and compliance checking can reduce the preparation time from the current 45 to 60 days to 15 to 20 days through automated aggregation from multiple sources and NLP-generated structured content. Plan evaluation. Comparative scoring algorithms can accelerate plan evaluation from 30 to 45 days to just 10 to 15 days by scoring competing plan on objective metrics like net present value, internal rate of return, and sector viability. Forensic audit pattern recognition for fraud detection could reduce the audit time from 60 to 90 days to just 20 to 30 days by identifying suspicious transactions, circular deals, and anomalies automatically. Beyond these core stages of CIRP, integrating AI in CIRP can also help in litigation management, with predictive outcome modeling achieving 85 to 90% accuracy. Automated hearing scheduling eliminates manual coordination. COC meetings benefit from automated reporting and analytics. Dashboard analytics could provide live CIRP status monitoring for all the stakeholders. Now, successful AI integration requires both robust technology and comprehensive professional development. We must transform both systems and skills simultaneously. So, the technology stack proposed includes NLP for document analysis, legal research, and case law analysis, machine learning for pattern recognition and prediction, resolution applicant scoring and ranking, blockchain for transparent tamper-proof audit trails, predictive analytics for outcome forecasting of resolution plans. Along with technology stack, we should have technical competency for resolution professional. These include AI literacy, digital platform management, data analytics, and cybersecurity awareness. Certain enhanced professional skills for RPs would be risk assessment, like evaluating AI recommendations versus professional judgment, stakeholder communications, like explaining AI-driven decisions to the committee of creditors or stakeholders, ethical decision making, balancing automation with human oversight, and change management, leading digital transformation initiative. So we will have a training infrastructure which has mandatory AI literacy for all RPs, specialized certifications, continuous education requirements for evolving technological landscape, and practical workshops on AI tool implementation. So my strategic phase deployment for AI integration in CIRP spans 24 months with clear milestones and measurable outcomes at each stage. Phase 1 is built upon IBBI's May 2025 digitization achievement, the CP form consolidation that provides our foundation. Phase 1 will basically stress on compliance and credibility. We will have digital infrastructure development, like setting up cloud repositories, uniform API for data exchanges, ensuring that IP, COC, NCLT are all connected to a single digital backbone. For example, we can build a digital claim portal where FCs and OCs shall upload claims based on their PAN and GST. Data shall automatically be cross-verified with MCA21 and GSTIN databases. We can also have some pilot small-scale AI testing modules, like for example, a pilot project where AI reads a petition and highlights the missing statutory requirements before NCLT filing. This will reduce a lot of defects. We can also have a chatbot which can give updates to creditors. Fourth part of phase 1 shall be professional training, which will be mandatory for mandatory AI literacy for resolution professionals. Next, we move on to phase 2, which will cover from the 12th month to the 18th month. Phase 2 will be core automation. Once the foundation is in place, we will have automation and predictive tools that can be embedded in the CIRP workflow. For process automation, an example can be a claim verification with AI cross-verifying creditor submissions through bank records, tax data, ROC filings, etc. Suppose an operational creditor submits a 2 crore claim, but GST filing reflects only 1.2 crore turnover. The system automatically alerts the RP for manual review. We can also have an AI document summarization for judges, like generating a summary of 400-page resolution plan for the bench hearing. We can have automated generation of cause list every day, which will trigger an email to all the stakeholders, including advocates, resolution professionals, defendants, respondents. Next, we shall include predictive analytics of CIRP outcome in this phase. Forecasting resolution probability, recovery percentage, time to resolution based on sectors, asset class, and past data. For example, before inviting a resolution plan, a system can predict that a real estate CIRP with stalled project has a 65% probability of liquidation versus a 30% probability of resolution, guiding improved COC strategy. Phase 3 will span a period of 6 months from 18 to 24th month. It will be full integration with real-time stakeholder dashboards, cross-border compatibility like international insolvency coordination. For example, we will have a predictive fraud risk scoring of resolution applicant based on past insolvency involvements. For example, suppose we have a global resolution applicant who is scored high risk because of its group entity defaulting in Singapore. This can be flagged before the COC so that they can take an informed approval process. Now, compliance is non-negotiable. Under the DPDPA Act 2023, we must manage consent, limit data purpose, and honor subject right with automated system. We should also have security safeguards in place like encryption, access control, and audit trails. For large-scale deployments, I have recommended appointing a data protection officer who will oversee the entire process. We shall also have algorithmic impact assessments for AI decision-making system. We will also have some independent audits for AI processing system. Every transformation now faces challenges also. AI integration in IBC is no exception. Of course, challenges exist like technical challenges and human capital challenges. Technical challenges include data quality issue like inconsistent formats across sources, data security issues, compatibility requirements, scalability concerns. Human capital challenges includes skill gap. Nearly 70%, 60% of RPs require AI literacy training. There will be change resistance, traditional practice adaptation challenges, and professional standards. So, for all these challenges, we have mitigation strategies like comprehensive training, gradual pilot basis may deployment, hybrid models where AI augments the process rather than replaces the human judgment. And there will also be continuous support for ongoing technical assistance and updates. My research conclusively determines that strategic AI integration is more than just a technological upgrade. It's about unleashing the full potential of IBC. The evidence is overwhelming. As you can see, that my research concludes with empirical evidence, AI can reduce CIRP timelines by 40 to 50% while improving accuracy. There is human in the loop principle. AI augments RP's work, but decision making ultimately lies with the RP, thus enhancing human judgment. Implementation feasibility, there will be a phased approach minimizing disruption while maximizing value. Regulatory compliance, DPTPA aligned framework ensures legal adherence. Integration of AI in CIRP also has a transformational impact. There is economic growth for the country, faster resolution accelerates capital recycling. It also boosts creditor confidence, improve recovery rates, encourage lending. There is professional enhancement. RPs have the mental satisfaction that they are now strategic advisors and not just administrative processors. We also have global leadership. India can be positioned as innovation leader. So we have technology that exists, precedents are proven, economic benefits are compelling, regulatory framework can be adapted, professional community is ready for upskilling. What we need now is a collective commitment. Question isn't whether to adopt AI in CIRP. Question is how quickly we can implement it responsibly. By implementing AI and integrating tools, we achieve faster resolution, higher recovery, and greater transparency while preserving the human element. So, what is the future? Future is a digital transform CIRP in India. The AI provide tools, and our commitment determines the outcome. Thank you.
You can ask questions.
Thanks, Salini, for the presentation. You have
Thank you,
covered
sir.
nicely, but one very important aspect, what we have been facing in the recent few arguments before the various forums at various judicial forums, the
Yes.
case laws and all which have been highlighted or been used as a evidence or for arguments that were never held. So, how did you try to cover this in your paper? What precautions the RPs and other professionals should take care while just focusing on the AI is one part of it, but how to ensure that the authenticity of the data, whatever tools you are using it, before once you go to any court of law and all.
So we have the Digital Data Personal Protection Act. So the RPs can, like the system, technology provider will provide such a system where the data will be secure. And another thing is like AI will give you the outcome, but RP shall not decide. RP will have his own human judgment and professional judgment based on his experience last 20 years in different sectors. He will use AI to enhance and speed up the process. He will not use AI will not replace RP.
That's fine. Uh, you have especially focused on how it can be helpful in more on realization of the claims and increasing the claims, especially for financial and operational debts. The lot more threat will be required. See, analyzing of the data, uh, using it for drafting and all that is fine. But in what aspects you want to more focus, especially in your paper, how the claim percentages can be increased with the help of the AI?
So if there is faster resolution, if the work is done faster, automatically our depreciation of assets will be less. So the realization for committee of creditors will be more. If the manual work is done faster, sir, then we will not lose time in extending the timelines of the CIRP process.
Fine.
Ms. Shalini,
Yes, sir.
one question for you. I believe that any kind of AI has some information asymmetry, correct?
Yes, sir.
So have you dealt in your paper that how exactly this challenge can be solved or has a solution for this?
So we have to educate RPs regarding prompt engineering. If we feed data correctly, the data will be proper. Even in terms of uploading the documents, the scanning should be perfect. AI should not read I as one or one as I and give a wrong result. So there is an entire subject called prompt engineering where RP will like give correct prompts. Like for example, if I want a due diligence of resolution plan, I cannot just give a prompt, ki, this is my resolution plan, give me the due diligence compliance. I have to specifically say due diligence in terms of compliance with provisions of law, due diligence in terms of whatever content is there inside, due diligence in terms of section 29A, like with whatever records the AI can pull in from the public records. So I have to specify what due diligence or what exactly I need. In that way, we will not have any informational asymmetry. Plus, we should have IBPI should introduce a uniform data standard for every, like CP form consolidation. They like the data is to an extent standardized now. AI can pass a CP form and tell what is the like what are the timelines, why the delay has happened, what are the delays. So in that way, information asymmetry can be reduced.
Yes, last part of it. Actually, they allege that AI will actually undermine the fairness of stakeholders.
Okay, sir.
Is there an answer in your paper?
So AI cannot see. We have independent. Yes, sir. There is an answer. We have independent audits on the algorithmic efficiency also. We will. Matlab, my paper suggests that we should have an independent audit even in the algorithmic decision making, and we should also have a so that independent audit will let us know whether who is whether the stakeholders whatever AI's decision is it being impartial, is it being partial. So the independent audits will help us know better, and we can always improve the algorithms. And as I said, sir, AI is not the decision making authority. It will just enhance the RP in terms of timelines. Ultimately, the RP will use his professional judgment, expertise of the number of years that he has worked in the sector, and he will he has to explain it to the stakeholders properly. AI will just help him like an assistant. Now, most of the RPs, sir, from what I have interviewed, they are all single people. Like they do not have a big team. Like a small CA firm, there are 2 or 3 assistants one RP has. But AI can act as a full office for an RP. He can have a legal assistant. He can have a person who will verify claims. He can have a personal assistant in terms of for the CIRP. Suppose he is managing 4 or 5 cases, sir, the AI can help him give reminders that in this case you have this hearing today. In that case, you have a COC meeting today.
Thank you, Appa.
Thank you, ma'am.
Thank you, sir.
I now request our third and last presenter for the day, RVN Ramakant, sir, to come.
Respected panel members, Dayananda Murthy sir and Sharif sir, and all the audience, very good morning to all of you. Today I'm going to present a paper on cross-border insolvency issues and concerns with special reference to India as well as abroad. So in this paper, I covered many aspects. First one is economic sovereignty, and the second one is economic nationalism, and the third one is reciprocal tariffs impact on cross-border insolvency with special reference to United States, what's happening around the globe, what Trump is doing. And the third one is communitarian vision in cross-border insolvency. And the fifth one is recognition of foreign judgments with special reference to foreign exchange problems. And the last one is harmonization of different private international law rules and as well as domestic insolvency practices. Here, if you observe all over the globe, around the globe, economic sovereignty is gaining a lot of momentum after globalization. Means once we introduced liberalization, privatization, and urbanization. And quite often, every nation try to grab investments to their economies just because of taking advantage of that investments and for national development and economic development. Generally, India introduced in 1991 new economic reforms. At the time, India stand at the edge of insolvency, almost bankrupt position. At that moment, P.V. Narasimha Rao government taken an initiative, and we have taken a U-turn from a socialistic approach to capitalistic approach. When a nation is taking a capitalistic approach, then problems starts and challenges starts. At the same time, every crisis is an opportunity. We have a lot of advantages of taking that U-turn. But it was nicely happened, and India took an advantage, and now we are becoming globally renowned economic power. But in this journey, the challenge is that while investments are happening from abroad, we have many challenges in the name of cross-border insolvency. One company is opening their subsidiaries across the globe and doing operations. If at all it gets insolvent, there is no proper law in India to address that insolvency position. So a redressal mechanism with reference to cross-border insolvency is so weak in India. We have one provision in IBC in the name of 234 and 235 provision, but it is not comprehensive enough to address or to redress the challenges of cross-border insolvency. Then how can you ask other nations, advanced nations like Singapore, United States, United Kingdom, please invest here? They look for the law. They look for early protection as well as mechanism to address these issues. Otherwise, investments will go in vain. So in this process, India also introduced that 234 and 235 provision, but it is not enough. And many reports and many recommendations given to Government of India to adopt UNCITRAL model law to make sure that we will also at par with global standards. But the problem here in adopting UNCITRAL model law is that once you adopt UNCITRAL model law, you have to give access to the foreign courts. When you are giving access to the foreign courts, direct access to the foreign courts with reference to the local assets hampers the creditors who are investing money here in India. So local creditors are going to be hampered. How to balance this issue? This is the most typical issue in cross-border insolvency. You have to respect foreign creditors and you have to respect local creditors, and you have to strike balance between them, and you have to solve that problem. In this regard, we choose an UNCITRAL model law. Government recommendations nowadays going towards choosing UNCITRAL model law. It is known as UNCITRAL model law, also known as modified universalism. Modified universalism is nothing but it is a combination of territoriality as well as universality. Once you choose a modified universalism, unless and until you stick to that modified universalism, it will not yield benefits. For example, if I have cross-border insolvency problem with the United States, if at all United States courts given such type of judgments based on modified universalism purely will gain benefit. But if at all they again intervene with territoriality principle, then the problem starts there. So to address these type of cross-border insolvency issues, we are till date talking about only adopting UNCITRAL model law. But my advice is that why don't you look for preventing insolvency at the very initial stages, and why don't you evolve a law which can prevent insolvencies at the earlier stages of its operation? That means by using artificial intelligence, data analytics, quantum computing techniques, quantum communications, you can assess what will happen after 2 years to a company, whether it will get insolvent or not. You can judge it. By that, you can take steps to prevent insolvency. Once you allow the problem and you solve the problem, means it will be cost-benefit analysis and it will cost effectively. So here, not only adopting UNCITRAL model law, you have to bring ADR technique to the UNCITRAL model law. So when you are going for ADR technique in unsettled model means you are going for mediating litigation. That means whenever litigation stucks there, you should not waste time by stucking there and postponing the case. You solve that case by technique of mediation. So mediation is better than in alternative dispute resolution. Mediation is better than arbitration. Why? Because mediation is so much simpler and cost benefit, and it will solve problems very quickly. In the recent, in the recent conference, Supreme Court judge also P.S. Narasimham, he addressed ADR conference in Vizag. He told earlier the litigation happening based on logic and reasoning, but nowadays the paradigm shift is towards trust. Unless and until you trust that process, you cannot yield such type of benefits. So the reason and logic based judicial process is going to be shifted towards mediation. That can be very good technique for solving even cross-border insolvency problems here in India as well as in abroad. So with this combination, if you apply artificial intelligence and if you prevent insolvencies, and it will be a more advantageous position in cross-border insolvency, that I suggested. And one more thing, in this Singapore judgment, very recently, Singapore High Court accepted the Indian insolvency resolution process. In that process, what we have to observe carefully is that India is not party to the unsettled model law, but Singapore is party. But yet, Singapore High Court acknowledged that Indian judiciary judgment. And with this, what we have to understand is that we cannot be a party to unsettled model law, yet we can gain benefit out of judicial process. This is one way. So at present, Government of India is looking forward to adopt unsettled model law. Meantime, we have to focus on international commercial arbitration technique embedded with unsettled model law will give more benefits in future by applying artificial intelligence and preventing this insolvency mechanism. So prevention is better than cure is my suggestion. With this, I conclude my presentation.
See, the focus was only on more on prevention. That's fine, well taken. But have you come across so many other instances in Indian judiciary right now you have not covered in your paper, or have you covered in some case law? We see that even cross-border insolvency was being given upend. Say Jet Airways case, if you see.
Jet Airways case, sir. Jet Airways case. That's why I'm saying this. Why prevention? I'm telling now. As sir said earlier, we have to solve this issue within 270 days. But it is crossing even 330 days also. And Jet Airways case, it has taken 5 years. 5 years means 1600 days almost. Singapore is solving the same cross-border insolvency problem within 180 days. When you are taking that much delay, what is the point of going for a separate entity for insolvency problems? So it is also delayed like civil courts. So can corporates wait for 1600 days? And the beauty of the judgment is that at the end of 5 years, they cannot go for corporate insolvency resolution process, and resolution application failed, and resolution process failed. Again, come after 5 years, Supreme Court order for liquidation. So to liquidate a company, we have to wait for 5 years. Why don't we do that at the very initial stages? And why don't you save that 5 years beautiful time? When you analyze this on cost-benefit analysis, Indian judiciary is failed based on logic and reasoning. That's why in the corporate sector, they are going for mediation.
In a country like India, with so much of cases being pending and huge corporates been there, where the matter which has already been under insolvency taking so long time, and then analyzing and doing prevention, is our judiciary, our legislative administrator is so much equipped to even focus on those cases as a more preventive measure, rather than even focusing on the cases which are on the hand. If you see unsettled model law, which is there on cross-border, it is from 1997. Now we are in 2025, say for example, and still we are not in a position to adopt that unsettled model law.
I will give a practical example.
Which has been 28 years old actually.
I will give a practical example. When you are going on the road with a bike, you make sure that bike must be very good in condition. Yet there is a possibility of accident. But if you go with your bike without checking and preventing all these things, there will be more possibility of happening accident. So I'm not saying that prevention is only the solution, but why don't we focus more on prevention first? Then, if at all prevention fails, and at any way, we have that judicial process and all this mediation and all this process will be followed.
Ramakant sir, I think your paper challenges IBC itself now. Okay. Whether IBC should be there or not, I think we'll not go back. That's a different issue. But business is always a risk, right? Probability are irrespective of how good the managers are.
Yes, sir.
There is a possibility of a loss which can happen to a company. Right? I understand that if you do it purposefully, manipulative, fraudulently, then I think there is no question of preventing anything there, because they did it with an intention to do something, right?
Why I said this one thing, sir, one of the Harvard University professor, they invented one jet score formula. By applying that jet score formula, they're going to tell after 2 years what will happen to a company, whether it will go into the process of insolvency
Right,
or
we
not.
understand. That's what I'm telling. If I am a manager, I'll try to hide all those things, right?
Yes, sir.
I will not make it public, and I'll not see that my child will be dying in that way, because I am a promoter. It's my child. The company is my child. I'll not allow him to die. So that's the reason why that possibility of taking precautions sometimes may not work out. Because he will try to save it at any cost. Correct, na? So I don't know how exactly you have analyzed your paper, basically. Because when you started with saying IBC should be there or not.
IBC should be there, sir. IBC
then,
should be there, and cross-border insolvency provision should be there.
Okay.
But along with that, better we have to take care of these preventive measures,
Right.
and ethical integrity and ethical working, improving ethical working style in corporates.
I think for that you should give away greed, which I think it's humanly impossible. Unless you are greedy, these kind of situation will exist. And you want to close the shop for everyone? No, right. Thank you, Appa. Thank you so much.
Yeah, as we completed a paper presenter for this session, and I now request CS Shaileb Bahati to give his concluding remarks. Thank you.
Once again, very good morning to one and all. Really nice, because the topics which have been suggested today are very diverse, which are evolving. So as rightly said by that, the IBC is still evolving, and the presentation given by Prerna or Shalini or Ramakant were on the topics on which still there is no conclusive law which is being framed. Say the AI is still evolving, cross-border provisions are not yet been implemented or been effective, and even virtual digital assets, even our government is not even in a position to take a conclusive stand how it has to go ahead, based on the judgment given by the Supreme Court in Internet and Mobile Association of India. And apart from that, in 2022, Ministry of Finance came with a taxation angle on virtual digital asset, but whether it really asset, how it is to be classified, certain amendments made under the Companies Act on classification of cryptocurrencies and all. But still, when it comes to linking it with IBC, making when the IBC concept is maximization of the wealth from the point of view of corporates, as well as for the point of view of the creditors who are suffering. But when it comes to now, first point which Prerna ji has tried to raise is about cryptocurrency and how it can help and ensure that there can be a maximization of crypto assets being part of the property from corporate's point of view, from RP challenges in realization of crypto assets which are there, whether it is in offline and online. And since it is into evolving prospects, maybe we can see that in next couple of years, government will come with a comprehensive framework on VDA, and professionals, corporates need to be more clear, have a clear idea how it is going to impact in wealth maximization for the corporates. Coming to AI, there is no second option, whether it's students, whether it's academician, whether it is corporates, whether it is RP. is how best you can use the AI. And undoubtedly, there is no second thought that it cannot be used for our entire process of CIRP. It will definitely streamline the timelines. It will help in wealth maximization. Coming to the third point of cross-border, it is the need of the hour. World has become a global village. Now, how much corporates you see are operating only within the particular area of the region? Now, if you see, every businessman want to have the business outside India. They want to do current account transactions, capital account transactions, purchase assets outside India. Foreigners want to invest in India. If there is no proper legal framework where the creditors, whether it is an Indian creditors, whether it is a foreign creditors, now Indian creditors to be protected against the mischievous done by the foreign companies. Similarly, foreign creditors should be protected against the Indian corporates. So, yes, 234 and 235, two important sections in the IBC, which are yet to come into the force, which has to be taken care. And at any cost, this has to be unsettled model law can only one of the way. But apart from the, unless and until we have a in detail framework to ensure whether it's a Videocon case or if you see SR Oil case or Jet Airways, it took a lot of time because we don't have a proper legal framework established law where even though we should appreciate a judicial system based on that judicial, they have tried to even implement in those cases how best they can ensure that even in cross-border CIRP, it can be done even when these sections are not been implemented. Once again, I appreciate all the presenters for their time and presentation given and all the participants here. But topics are really excellent and the topics are evolving where there is no settled law. So maybe in next couple of years, we'll have much more clarity even on cross-border as well as VDA. And AI anyway, it is more of a process which has to be used to ensure that the things get more streamlined and more faster and maximum wealth can be certain for all the corporates and everyone. Thank you.
Thank you, sir, for summarizing and your concluding remarks. As we conclude this session, it's as a token of love and gratitude. I now request CS Manjit Butcha, Chairman of ICICI Hyderabad chapter, to come forward, presenting a memento to our panelist, Dr. Dayananda Murthy. Thank you, sir. And we have another panelist, CS Shailesh Baheti. I now request CS Sai Sudha to come forward for presenting a memento to our panelist. As we conclude, it's my privilege to give vote of thanks. We thank the esteemed panelists and the paper presenters. And also we would like to thank our sponsors, particularly Dolphin Foods India Limited, Veeramani Biscuits, and also special thank to CS KVS Subramaniam. And also we thank Bambino Pista and the company secretary CS Shilpa Kotagiri. And also a special thanks to our manager for this session, with handling this session. Thank you, Ashwasti, for your this thing. And before we conclude, we have a small presentation by E-Mudra, one of our sponsors for this session program. I request E-Mudra to come forward and present their presentation. Thank you.
sir, that is presentation. We have a product presentation through website. So we have to connect our laptop. We can log in. Huh? Share you the credentials.
So I'm just checking my clock to check whether I should say good morning or good afternoon. I think we have 5 minutes to say good afternoon to all of you. We are always told that Australia is always in between India and the World Cup, right? I think we are in between you and the tea break. So we've been told very strictly that it's just 10 minutes that we need to finish. So we'll try to be as quick as possible. We'll try to keep it as interesting as possible. So this is going to be a slightly different presentation. We come from E-Mudra. It's a company based out of Bangalore, purely an Indian company. And many of the people here, company secretaries, associate us with digital signatures. So we are a digital signature company, synonymous with the word digital signature. So anybody who has a digital signature in your organization or your college, 5 out of 10 times they'll be having a E-Mudra digital signature, because we have 50% market share in the market today. So this is going to be slightly a corporate presentation. We are from Bangalore, so we are an IT product company. So it's going to have a little bit of technology also. And we are going to connect this. Why are we here on the ESG dais, bringing a IT company, IT product? How is it connected to ESG? And also the fact that what is in it for all of you here. So we are going to tell you a way to take you through this journey, what E-Mudra is offering to you can carry it forward to the citizens of India, and how can you be part of the success story of E-Mudra. So let me move on. So quickly about me. So my name is Janardhan. People call me Jana. So I'm heading customer success at E-Mudra. So before this, I had started my career with Citigroup in Chennai. Then I had moved to GE Money, GE Countrywide in Chennai again. Then I worked in Religare Invest in New Delhi. And then I was in Hyderabad, not new to Hyderabad. I've been here 13 years back. I was working in Amazon. Then I made a very interesting decision to leave Amazon at a very prime time and then join a company which was just 4 crores in revenue and which had 50 employees in Bangalore. And even my dad was not supporting me, and he was upset that I didn't go to US. Rather, I decided to join E-Mudra in Bangalore in 2012. And it's been 13 years I've been living my dream there. So I'm going to show you how this whole journey has panned out for me and E-Mudra the next few slides. So I'm introducing my team. Our chairman is not here, but he's always present. He was the company secretary of ICICI Bank. He was reporting to Kamath. He became the founder chairman of ICICI Infotech. He moved to US, which became 3A Infotech later. And E-Mudra was a small project inside 3A Infotech, and it was hived off. And now E-Mudra stands as a separate company in 2025 with a revenue of almost 500 CR and a market cap of almost 6,000 to 7,000 crores. So he's been the brain, soul, heart, everything. So with his blessings, we have been. So I'm not going to talk about me, which I did in the previous slide. So we have our company secretary, Johnson, who is there in the crowd. So I introduce him. He has also been there for 13 long years. So we have been sailing in the same boat. I think he also would have got challenges from his family. Why are you joining a small company? So we'll tell you what our journey has been. So I have Jai Shankar here, who is head of partner sales, who's also been with us for 11 years. And then I have Girish, who is partner sales manager for Andhra, Telangana. So he's there with, who is a B2B specialist who deals with large corporates. She's here. So apparently all of us speak Telugu. So that's another familiar point. So yeah, journey of E-Mudra started in 2008 as a purely digital signature company, got certified by CCA for only issuing digital signatures. We were a very small company competing with the likes of TCS, SIFI, and we just came our way through 5-6 years consolidating our position. And then 2015 is a very important year because that's when we actually architected digital signatures based on Aadhaar instead of a dongle token. So we helped the government in the Digital India vision. So e-sign based on Aadhaar is one of the brainchilds of E-Mudra. Then we also started building a lot of softwares. The most important software is the M-Signer software. The most important point in the slide is we did not just hold on or hold back being a digital signature company. We tried to innovate, we tried to move into the cryptography and the PKI technology behind digital signatures. We started doing a lot of R&D. We started creating a lot of solutions and product. From being a DSC commodity company or a certifying authority, we started moving as a solution company with a thought leadership in this space. So what eventually has happened is we created E-Signer. E-Signer is the hero of this presentation, so we're going to touch about that more. And then there are also other PKI-based products which have come into picture. Now we are moving towards zero trust PKI in cyber security across different countries. We are present in multiple countries today. And we are also moving towards Gen AI and converged identity. So these are very advanced concepts. Very proudly, we can tell you that we are one of the very few, or maybe only one vendor in India who are kind of present across all phases of PKI. And we are competing with the likes of DocuSign, Adobe Sign, a lot of American and UK-based vendors in this space. And we are kind of replacing them in many places due to our competency. So it's an Indian company with a global soul. So that's how the journey has been. I can clearly tell you this is one of a kind company because we are one of the product companies in India who had grown up into becoming a global company. There are a lot of IT companies which are services companies which have grown up, but very few Indian product companies go up to the global scale company with the global American companies, but we have been able to successfully do that. So this is what we have grown into. So the time I joined, we were like 50 employees. Now we are 800 plus, 10 offices in 30 different countries. And I spoke about our market cap. We have a lot of IPs on digital identity and PKI. And E-Mudra, right? So Mudra is a Sanskrit word, which actually means seal. E means electronic. So it's electronic seal. The whole concept of the company and we breathe something called digital transformation for India and other countries, which we touch. So the whole vision and mission is around digital transformation. So if you look at, this is one page on our website, a very random first page. And then if you see all of that, our values and principles, and that so we can actually call it as DCB philosophy. I think we are all talking about ESG. What is DCB? Everything that we do is cornering around digital, and then cornering on compliance, customer, cost, and finally everything has a Bharat to it. So everything is stamped Indian and it's built in the Indian way and then promoted in the global field. So that's what we are. So our products are classified into two sides. Left side is trust services, right side is enterprise solutions. To put it very simply, left side is all signature certificates. You see the first block in orange, that is our individual digital signatures. Second block is SSL certificates for IT infrastructure. And then third one is device certificates. I'm not going to go into the detail of it. This is the side we are very popular with the company secretaries and chartered accountants because this is more of a commoditized market. And then this is high volume, low value market. So basically you get a digital signature for 1,000, 1,500, 2,000 rupees in the market. So this is where we have 50% market share. We have always been known as a digital signature company, but there is a hidden side of it. We are a 500 crore company with 100, 150 crore coming from the left side, but 300, 350 crores coming from the right side in India and abroad. So enterprise solutions are products that we have built that I spoke about. There is M-Signer, there is Secure Pass, there is CLM, but we are going to be more concerned about the first one. So now, what are the characteristics of digital signature? So primarily, we sell it through partners. Who are the partners? Chartered accountants, company secretaries, and small enterprises. And then it is token-based or Aadhaar-based. This is known by most of us. And then we are the market leader in it. And it is a mass market product, and we are a household name for digital signatures. But what is the characteristics of the ones on the right side? It's for large enterprises. We are customized solutions, which are primarily on-prem, some of them on cloud. Your channel partners are large SIs like Infosys, Wipro, TCS, Tech Mahindra, through whom we distribute those products. And then if you look at the clientele, government, defense, BFSI, large enterprises of high scale. So one challenge or one important initiative or objective this year for us, how can we move one of those solutions into a mass market product? So the best product fit is M-Signer, and then we are trying to bring it to the mass market. So how are we planning to do that is what I'm going to explain you quickly in the next few slides. So for that, we need to understand what is M-Signer, right? So some of you, this is the modular architecture. I said this slide becomes a little technical, but I'm going to explain it in a very non-technical way as much as possible. So do not worry about all the blocks. Look at only the workflow in the middle. So that is the engine, core engine of the software. So which simply allows you to upload any document which is a HR letter, offer letter, company secretary related, related documents, or any documents. You just go to the portal, upload it. You can actually define multiple levels of signatories. You can have n number of signatories. You define the signatories, internal to the organization, external to the organization, and then you can start sending the document for signature. For example, HR offer letter. HR executive can upload it, send it for signature to the HR head, and then it can go to a candidate who's sitting in Assam or Kashmir for a signature. So it can all happen online. That's the workflow engine. Coupled with the signing component, the signing components allows you anybody to sign using a dongle-based signature, Aadhaar-based signature, any signature which is relevant to that country. UAE pass-based signature in UAE, and European signatures in Europe. Simple electronic signature, which is a scribble-based signature in any part of the world, including US. So we can configure everything connected to that particular country. So it's a workflow e-signing software, which has all types of signatures, and very interesting features, the online e-stamping. We are also connected to NESL, and if you want signing a contract with an employee or a vendor or anybody, you can actually pick up a stamp paper online which is valid, and then we can attach with the PDF, sign it, and send it. So whole paperwork of the last leg, printing, signing, putting a stamp paper to it, everything basically becomes digital here. So the other aspects, you see there is a doc store. You can have different types of authentication. You can actually deploy it by cloud, on-prem. You can use via mobile. You can use via your laptops. And then we can connect it to all the core banking softwares or other core ERPs in the world. This is the whole modular architecture, which is primarily deployed as an on-prem solution for large organizations. Now, if you have to take this to the mass market, we have to knock out a lot of blocks because we can't take it this way. So primarily, it should be available on the cloud for you, like a LinkedIn. Just log in, subscribe, start using. So what have we done? We knocked off a lot of blocks. It's primarily only available on this plan we call is M-Signer Bharat plan, and then we have it on cloud. So we have a workflow engine running, we have a signing engine running, we have all the signature configurations, and we have online e-stamping running. So this is a simple piece that is there. So now I can quickly show you, this is the architecture. I can show you one more aspect we are building now in the beta phase is trying to connect this to WhatsApp. So we're building a system where you WhatsApp, you get a PDF, say for example, rent agreement. You can actually sign it there itself and attach a stamp paper, e-sign it, send it to the next person for signing. So that's something that we are building, but currently it is available on our website, this piece other than the WhatsApp. So I'll quickly show you a demo of how the upload, sign, and send happens. After that, I have a couple of slides to close. This is the software that's there on the cloud on our site called msigner.com. So when you have time, there's a free trial account. You can actually explore it. There'll be different plans. You can go after the Bharat plan. That is the simplest version of all. So once you log in, this is what you will see. So any PDF document or different types of Word document, you can just upload. Yeah, document is uploaded now. You see the preview of the document. Let's assume this is an offer letter, right? So it's just a CV, but we can just assume it's an offer letter. You need to sign on it. It's setting up a signatory, who's to sign, in which part of the document you need to sign. The different types of signature will go with the scribble signature. Yeah, so that's it. So you configure an email ID, it will just go to that email ID. And you can also configure the other person as a signatory. So you can configure n number of signatories. This is purely legal in India, right? So all the signatures that are available options are legally valid in India. Okay, so we didn't go very detailed because of want of time. That's as simple as that. It's a 2-minute procedure. So you can just get it started, push. So that is the quick thing. So how are we connected to ESG? So this particular software actually completely makes life presenceless and paperless. So which is completely complying with the environment aspect. It cuts down the complete carbon print. All papers completely can be eliminated. The last leg of printing and signing, including the stamp papers. So social, right? Digital inclusion to the last mile. India has 90 crore smartphones today. So almost 2/3 of the population can be included in this process of digitizing, digitally signing, cuts down the cost incurred by individuals for paper signing, loan processing, and then digital revolution, like a green revolution, white revolution. Today we are in digital revolution. This product was very handy during the COVID. A lot of banks use this software for signing, and then provides opportunity for partners. So it's not just E-Mudra wins through this or earns or monetizes through this, but we also do economic upliftment of all our partners. So that's very important objective of any corporate. So that's something that I'll cover in the next slide. So governance, this has all the legal trails. Digital signature is the epitome of security, and it has all the logs and all the digital trails for you to audit. So company secretaries being the custodians of compliance, I think digital signature, I think you'll vouch for the fact that digital signature makes life more easier in that compliance aspect. So now quickly, my last few slides. So what is this benefit for you? So that one part I said, one of the social objective of the product is to include everybody in monetization and economic development and upliftment. So how do we do that? So company secretaries here or future company secretaries here, anybody can enroll as a partner for E-Mudra through our portal. It's again an online process. When you do that, the charity starts at home, right? So you can actually refer any organization, your organization, any department, HR, legal, finance, digital initiatives, anybody who's using paper documents. So yesterday when I checked into a hotel, they were still writing paper applications for me. So it was very surprising. So you can refer them to us as for a digital transformation initiative. And you can refer large organizations which you do consultations. We'll be more than happy because quite a lot of organizations are our customers. And then the most important thing, this is the mass market entry. So you can start the link that she opened, right? The link you can actually send it from your partner ID. Anybody signs through it and pays through it. There is a commission that immediately gets automatically. It's more like an Amazon, Flipkart commission kind of a situation. So you will get up to 25% commission. And then you can also have sub-partners. If sub-partner is referring somebody and the sub-partner is mapped under you in our portal, you will get up to 10% of the. So basically, these are all the ways the social part of it taken care of. This is my last. What are the benefits? No upfront investment. Your no capital is getting blocked because it's purely a referral bonus. What will I get out of this? You look at this number, it's very alarming. 60 to 75 crore smartphones. Some numbers keep it at 90 crores for India. So everybody who has a smartphone can use this product. That's the kind of revolution, the digital revolution we are talking about. AP and Telangana itself has 10 to 15 CR. So even able to tap 1% of this population into this business, the kind of money that is there for economic benefit is quite enormous. Products easily available on SaaS. It's a subscription model. You don't have to go and implement a software, take long cycles of implementation. You saw that in 3 minutes, she was able to sign a document. Instant 24/7 commission payouts. It's a 24/7 automatic system. And India, it's the only Indian OEM who has this kind of product today. And we are a thought leader. We have a very strong brand in the space of digital signing. And flexible and competitive pricing. So there are two models. Bharat plan is 1,000 rupees per user. It's very economical for Indian consumers. And also there's one more model called pay and sign, which is per document you can go sign for 100 rupees and come out if you don't want to do 1,000 rupee and repeated signing. So that's the kind of flexibility that does Indian pricing for Indians so that the mass market adoption becomes much more easier. Yeah, so this is my last slide. This was the answer to my dad's question of why didn't I go to US. So today we are actually a company which has grown from India, and we have recruited people from US in our organization. So if you see a lot of Americans, and we have a lot of Europeans there, people from Southeast Asia, Indonesia. So this is a core leadership team today. It's looking like we are an 800 company organization, and this is where our offices are in 13 years in most parts of the world. And let's partner for a trusted digital future. And that's all I have for. Thank you.
Thank you so much, sir. Now the participants and panelists can leave for the tea break. It will be served near the Thinking Man statue.
The next session will start in 10 minutes, so you can finish your tea in meanwhile.
Do we have Miss Devika Singh here with us? Okay. Can Aishwarya, Satija, and Kritika Podar ma'am hear me?
Yes.
Yes.
Okay, thank you, ma'am. So good morning to everyone. We'll be starting the session now. Good morning to everyone present here. I hope the panelists are comfortably seated as of now. I'm Ashwanshi and I'll be the session manager herein. Kindly let me know of any issues during the session. The structure for this session starts from an opening discussion by one of our panelists and concluding remarks by our second panelist, followed between with two paper presentations. I would like to now call upon Mr. Jayesh Sangrajkaji and Ms. Harita Deviji to kindly come to the dais. We welcome you to this conference, ma'am and sir. I would firstly like to give a brief introduction to both of you. So, Mr. Jayesh Sangrajkaji is the founder of Jayesh Sangrajka & Co. LLP, co-founder of InCorp India, and designated partner at InCorp Restructuring Services LLP, with over 37 years of experience in insolvency, corporate restructuring, finance, and M&A advisory. Among the earliest registered insolvency professionals with IBBI, he has resolved debt claims exceeding INR 30,000 CR, safeguarding the interests of over 25,000 home buyers in real estate insolvencies, and successfully led 20 plus CIRPs. Having facilitated fundraising of over INR 6,000 CR, he is a trusted advisor to corporates and government agencies, a sought after speaker at premium institutions like ICAI, IIM Ahmedabad, and IBBI. He also contributed to ICAI's landmark publication on stressed assets, cementing his reputation as a leading figure in India's insolvency and restructuring landscape. We are more than delighted to have you here, sir. Followed by Ms. Professor Dr. R. Harita Devi. She is a professor of law specializing in commercial and constitutional law with over 35 publications and 80 presentations at national and international forums. A graduate of Government Law College Trichy with LLM from Kochi University and a PhD from TND-ALU on reproductive rights of women. She has authored books, edited volumes, and contributed significantly to consumer law, including projects with the Ministry of Consumer Affairs and the Tamil Nadu Pollution Control Board. She had served as editor of leading law journals, coordinated national events, and guided 8 PhD candidates, 3 of whom have been awarded degrees. Thus, it's an honor to have you here, ma'am. I would now like to call on our first panelist to have an opening discussion.
So, good afternoon, everybody. Thanks for this opportunity to Nalsar University. I'll be very brief on my point on these 3 papers. I have gone through it, and they are very, very interesting topics and papers. Last session also I was there. The topics were amazing, and I really appreciate the efforts taken by all of you for presenting such papers, such nice papers. I have got 40 years of experience in financial field, and last 7 years, as was told, that I have resolved more than 30,000 crore and impacting 25,000 home buyers. So it has been amazing journey, but with the changes what are required are futuristic. Whatever discussion we are doing, most of the thing will be futuristic, like use of AI, use of convergence of technology, digital creditors, and tools like ADR, etc. So these are all great topics which our paper presentation will be there. And I hope all of you will like it, and we will also contribute our part. Thank you very much.
Thank you, sir, for your remarkable words and for addressing this gathering. I would now like to begin with the paper presentations and call on our first speaker of the day, Ms. Devika Singh.
No problem. No problem. Okay. Okay. Greetings, everyone. I am Devika Singh, an associate from Finlex Law LLP. So the title of my paper is The Phoenix and the Data, the Jurisprudential Renaissance of Personal Insolvency. So everyone must have heard about Vahi Shunya Hai, Vahi Tika Hai, which is associated with Shiva, embodies both Shunya and Tika, the void that dissolves and the point from which all the forms arise. The phoenix rise from the fire, reminding us that ending carry the seed of creation. Similarly, personal insolvency transfers despair into resilience and a new beginning. So I would like to state a history of war. which is from Germany, Phoenix, Wings of War. During the war between Germany and the Axis power, Japan destroyed the air bases, leaving the commandos uncertain about where to land their aircrafts. They turned to Hitler. His reply was cryptic and very commanding, asked to look at the geography of Germany, which was naturally suited for landings. Though his grand infrastructure projects were not originally developed for military purpose, they indirectly proved useful during the war. So, detailing the metaphor, awakening from the ashes. Earlier, personal insolvency were fragmented, leaving guarantors in long battles. Phoenix metaphor framework rose from the ashes of outdated laws, balances creditors' recovery with the debtor rehabilitation through combined reforms. So society once used to cast stones at the debtors. Today, it is a gate to renewal. The ashes of disgrace gave rise to the phoenix of dignity. First flames of reforms spark of rebirth, IBC 2016 and Part 3. Part 3 effective from 2019 organized personal insolvency resolution into two main processes. First, start processes. This allows the individuals with small debts to get a fresh financial start. Insolvency resolution process. This address higher value cases, often involving personal guarantee from corporate debtors. Key provisions included interim moratorium replacement, plan submissions, rules for valuing assets. Unclear areas were scope of the moratoriums, prioritization of creditors, which led to judicial interventions. So FSP, that is a fresh start process, reflects the early flight of the phoenix, allowing low liability debtors to rise from their financial struggles. Flames of legislative renewal amendment of 2024 and 25. So removal of or interim moratorium. Before the amendment, the moratorium protections were available to the personal guarantors of the corporate debtors. Now they no longer automatically receive moratorium protections. Mandatory creditor meetings. Prior to the 2025 amendment, if the debtor did not submit a replacement plan, process stalled, no clear path for the creditors or the resolution professional. But after the amendment of 2025, the resolution professionals with the creditors' approval must move the adjudicating authority to record the non-submission and seeking directions that close the loopholes and put pressure on the debtors. Automatic progressions to bankruptcy. If replacement plans are not submitted within 25 days, IRPs may end, allowing the creditors to seek bankruptcy. Prior to the amendment, it was not clearly codified and ambiguous post. Amendment eliminates gray areas and bring predictability. Clarified government dues. Prior to the amendment, if the government says this tax has a charge on the company's property, the court sometimes treat the government like a very secured lender that government could jump ahead of bank in getting paid. So post amendment, now the laws say clearly government due don't become secured just because a law says. So the banks and the other secured lenders priority first, the government claims comes later. Expanded avoidance of transactions. The law covers if they try to hide transfer assets unfairly, those deals can be cancelled and assets pulled back. Earlier, only companies could be caught. Now, guarantors can't escape either. So each amendment strengthened the system, helping the rise like a phoenix, like a phoenix. So the wings across the broader international perspective on personal insolvency. The guiding stars on the phoenix ancestral principles. Ancestral's legislative guide on insolvency law has been a valuable reference. It recommendations on the debtors protection and procedural transparency. Lifting of the phoenix, UK's insights. The UK's insolvency frameworks focuses on early creditors' engagement, professional oversight, and organized repayment plans. By including the similar features in the RPs um, efficiently and proactively without any delays or misuse. The transatlantic sparks the US lessons. In the US, automatic stays, asset exemptions, and court oversights protect the debtors, ensuring the creditors can recover what they are owed. India's court have follows these ideas by differentiating between the types of moratorium and safeguards, essentially assets and personal insolvency cases. Southeast Horizon Singapore model. Singapore brings all together corporate and the personal insolvency processes, enabling the uh, um, unified management by the RPs. India reforms joint RP management for corporate and personal cases. Show a phoenix rising with a wing strengthened by a lesson of Singapore. Fire of jurisprudence, judicial interpretation, and clarity. Embers of the constitutional validity. In the ruling of Lalit Kumar versus Union of India, confirmed that Part 3 of IBC is constitutional. It validated the inclusion of personal guarantors in the insolvency proceedings. Court recognized that it served two purposes: to protect the creditors' interest and give debtors a fair chance to recover. These rulings allow personal insolvency to emerge with legitimacy. Blaze of co-extensive liability. In SBI Ramakrishnan and Surinder Jiwarjika versus Omkara, SC made it very clear that the approval of the corporate resolution plan does not free personal guarantors from their liabilities. This maintains shared responsibility under Section 128 of Indian Contract Act, also upholding the idea that the personal guarantors are the distinct but connected and corporate duties. The court provided guidance to promote fairness and to protect the creditors. Wings of asset restoration. Court have made a clear distinction between the corporate moratorium under Section 14 of the interim moratorium under Section 96. Section 14 protects the corporate debtors. Section 96 requires personal debtors to apply for a moratorium. Judicial discussions stress on the fair procedure, lowering the risk of unfair advantages of the creditors. The fairness ignites legislative and judicial fusion. With more than 4,277 IRPs application against the PGs, the system shows it works very well. Annual report of 2024 and 25 of the Ministry of Corporate Affairs in 2024 and 25, along with court clarifications, bring together law and the legal principles, create a clear paths for resolution and rehabilitation. Conclusion: just as the Germany's geography and the infrastructure, though not built for the war, helped commandos navigate safely after the Japan destroyed their air bases. India's personal insolvency framework has provided guidance through the financial turbulence. In IBC 2016, Part 3 in 2019, and with the recent amendments of 2024 and 25, judicial clarifications have the structured process for the personal guarantor, balancing data rehabilitation with creditors protection. Like a phoenix rising from the ashes, the personal insolvency regime turns past weakness into the procedural clarity, fairness, and sustainable path for debt resolution. Thank you.
So you are finding out, I would say, IBC code, how far it is helpful to personal insolvency proceedings, right? So as on now, according to you, the present amendment, like till 2025 amendment, you are saying that personal insolvency proceedings becomes easy, or what is your actual conclusion, right? In one sentence, if you say, whether they are really benefited.
Yes, ma'am. It's
or still, is there any loopholes in this law or amendment or whatever?
There are loopholes, but like subsequently there are changes which is like helping the personal guarantors to overcome.
Because basically when this IBC code started or when it was brought into, everything was concentrated on companies
Yes,
or
ma'am.
corporates,
Yes, ma'am.
right?
Yes,
So
ma'am.
now you are coming out with a paper where
Yes,
you are
personal
talking
guarantor.
about personal guarantors. So then how far it is helpful or how far they are taken
So
forward?
mostly they focus on liquidation, but now they are providing the rehabilitation measures, like focusing on rehabilitation. At the same time, creditors getting the benefit of like whatever they owe.
What
Yes,
can
ma'am.
be done better? Like, don't you think now also the time period taken for all this is still
Yes,
the
ma'am.
same?
Yes, ma'am.
Because the aim behind why IBC code came was time.
Yes.
Resolution processes should be very quick and
Yes, ma'am.
things must be done, because earlier under the old winding up procedures, winding up itself will go for another 10 years.
Yes, ma'am.
So that was the, including your point of personal, how many people individually were affected apart from corporates. So now that has changed. So
Yes.
to change that or to bring a sea change to that, only this code came.
Yes, ma'am.
And through the amendment, now little bit personal guarantors
Yes.
are also taken into
Yes,
consideration.
yes, exactly.
So what more can be done? What is your specific suggestion?
As of now, I'm not, pardon me, I'm not much aware of that, but I feel that they're trying to make changes which is like beneficial for the personal guarantors, so that they can overcome these issues whatever they were facing previously, ma'am.
So it is a good paper, but practically, I will just add, I have handled more than 20 PG matters as a resolution professional. So there are a lot of insights which you can learn from the orders which have been passed, how the process goes and all that. The second thing is, most important thing is the whole process got delayed because of the constitutional validity, because it was challenged, and after 3-4 years, it was implemented in 2019, but it took 3-4 years just to, yeah, so that can be highlighted in your paper. The proposed IBC amendment bill is, there are many changes regarding timelines. That timelines and it has even in CRP process as well as personal guarantee matters, the timelines are have been tightened, and that is also very effective. Forensic audit. See, as a finance guy, we should all of you should also understand bit of finance also, because without understanding finance, resolution becomes difficult. Law we all should know, but understanding finance also we should know, because it is a matter of asset, liability, and how it will be discharged. So forensic audit and all that also becomes very critical. Then another one more point, car loans, for example, or small housing loans, or any other type of loans, they are not yet covered under IBC process. So that impacts the CIBIL score of everybody. So that is a very suggestion should be that all this should also be covered. So even personal loans should be covered. Otherwise, it impacts your CIBIL so much that you cannot do a fresh start. Also, you will not get a fresh loan. Also, these are all critical areas to look. And for all of what are the challenges faced in the process by a resolution professional, that also can be highlighted, because challenges are that the fees are very minimum in this process. As an RP or as a for legal advisor also, nobody is taking it so seriously. But nowadays what I am seeing, I am from Mumbai, so whatever I am seeing today is that more and more cases are getting admitted. So first stage is admission, and then even after, if there is no resolution, you are not spoken about a resolution plan. What plan creditor has to give. So that is so debtor has to give. That is not there. So there are a lot of challenges in giving plans also. And if otherwise it goes into bankruptcy. Bankruptcy trustees are appointed. So nothing has been. You can mention about the bankruptcy trustee also. That is a second part of it. Overall, it is a good paper. It covers theoretically many things, but out of 3,000 cases, how many cases have been resolved or how many have gone into bankruptcy, that all needs to be checked. I appreciate you have taken a lot of effort, and thanks a lot. Thank you.
Thank you, sir. Thank you so much.
Now, I would like to call upon our second presenter for the day, Ms. Aishwarya Satija and Kritika Podar, who will be presenting online. You may begin.
Okay, thank you. Hello, good afternoon, everyone. I'm Aishwarya Satija. I'm joined by my colleague Kritika Podar. We are both research fellows at Shardul Amarchand Mangaldas. Our paper today talks about mandatory regulatory clearances in CIRP. We specifically focus on CCI approvals required for resolution plans, and we also go in detail on the INSCO versus Giri Sriram judgment. I'll just give a brief introduction of our paper. So there are two distinct roles that regulatory authorities play in an insolvency process. One is as a creditor in an insolvency process, and the second is as a regulatory authority. So as a creditor, the role of any regulatory authority, like any other commercial institutions, is to get recovery for their debts. And their idea is to get maximize their recoveries. Whereas as a regulatory authority, they are supposed to take in public interest. They're supposed to decide whether they can attach assets if they have authority to, whether they should give regulatory approvals to any changes made in the resolution plan. And therefore, there are two distinct roles that regulatory authorities play in an insolvency process, which makes their role distinct from how commercial creditors behave in an insolvency process. This is also important because there is no guidance on how regulators are supposed to balance these two positions. And we'll talk about this in more detail in our paper. What happens in a CIRP once a corporate insolvency resolution process is commenced? A moratorium is applicable. A moratorium is a stay on various actions against the debtor. And one of the things that's stayed is that any licenses, grants, etc. that are given to the corporate debtor cannot be terminated or suspended. This moratorium lasts till the resolution plan is approved or till a resolution plan is not received and then a liquidation is initiated. But this moratorium continues till the CIRP or the corporate insolvency resolution process is completed, either by approval of plan or by initiation of liquidation. Now, there are several actions that can be proposed in a resolution plan that require regulatory approvals. You will have change in management, you will have a change in the structure of the corporate debtor, you could have a merger, amalgamation, etc. Various such actions require regulatory approvals depending on the terms of the resolution plan. The IBC provides a one-year period for availing such approvals. And this is a directory timeline. Initially, the IBC did not have any timeline for regulatory approvals. However, an amendment was enacted in 2018, providing this based on ILC Insolvency Law Committee's recommendations. So after the plan has been approved by the National Company Law Tribunal, there is a year-long period for the resolution applicant to avail these approvals. In practice, however, such regulatory approvals take longer. There is a different treatment for CCI approvals. So any mergers, amalgamations, etc. that fall within the meaning of combinations under the Competition Act require an approval from the CCI. These are usually change in structure of the corporate debtor that is above certain monetary, asset-based, etc. thresholds. Now, these approvals are received from CCI, unlike other approvals which are received after the approval of the resolution plan by the NCLT. CCI approvals, as per the IBC, are required before this stage. Specifically, if the provision of the law says that they are required before the COC approves the resolution plan, and I will explain these two distinct stages of the CIRP. The Insolvency Law Committee, which recommended inclusion of this provision in the IBC, also recommended that a 30-day timeline be provided for CCI approvals, which, however, is not reflected in the IBC. Our paper is premised on the lack of clarity that emerges from case law on this subject, specifically on the time at which CCI approvals are required. We also discuss the proposed amendments in respect of this and make suggestions for what can be done better on ground. So some of the issues and considerations that we focus on are firstly for regulatory approvals to be availed after a plan approval. These are general regulatory approvals, not the CCI approval. Now, these are very important for a resolution plan because the success of a resolution plan is contingent on regulatory approvals. Any resolution plan can only work out if all the terms and conditions in it are followed. And part of this is regulatory approvals because these will be required for the turnaround of the corporate debtor and for the resolution applicant to operate the corporate debtor as a going concern. There are conflicts in these dual roles of the regulator, like I explained. And there's no guidance on how regulators are supposed to balance their role as a creditor versus as an approval authority. For instance, if a regulatory authority knows that their approval is really, really important, can they bargain for better payouts in a resolution process? And this could happen in practice and does happen in practice. However, this distinction is not very sketched out in any standards of procedure or any other material that guides regulatory authorities. Now, the effect of failure to get regulatory approvals is a little unclear in practice. Although Section 33(3) and 4 of the IBC provide that the liquidation is supposed to be initiated if the plan cannot be implemented, there are certain regulatory approvals for which resolution applicants will often get extensions from NCLTs, and in most cases, NCLTs are hesitant to order liquidation merely because of some terms not being met. In Taguda versus State Bank of India, RBI approval, for instance, was not received for 3 years after the approval of the resolution plan. And in this case, then NCLAT directed NCLT to expedite the liquidation order. However, this is a span of 3 years after the approval of a resolution plan in which substantial change in value occurs. And these kind of cases kind of highlight the issues with receiving regulatory approvals after a resolution plan is approved, especially where timelines are so extensively breached. Now we come to the CCI approvals issues and considerations. So, like I said, there's distinct treatment in law of CCI approvals. Section 31(4)'s proviso says that a resolution applicant is supposed to get CCI approval before the COC approves a resolution plan. So just for context, a resolution plan is first to be approved by the COC, by the Committee of Creditors of the Corporate Debtor, by 66% in value. Once this is approved, then the plan is submitted to the National Company Law Tribunal. And once the plan is approved then by National Company Law Tribunal, it is final and binding on all stakeholders.
Excuse me, ma'am. Sorry
yeah.
to interrupt you. Your PPT slides are not changing. Could you try resharing your screen maybe?
Sure.
Yes, ma'am. Now they're visible. Thank you.
Oh, they're visible now?
Yes, ma'am.
I think I still have to okay, sure, I'll just go on. Right. So, sorry. Yes. So plan has to be approved by COC first and then NCLT. Now, some of the important decisions in this context are in the ArcelorMittal case. The NCLAT held that Section 31(4) of the proviso of 31(4) of the IBC is not mandatory, meaning that CCI approval can be received even after a COC approval has been granted, as long as the CCI approval comes before the NCLT approves a resolution plan. The NCLAT held that it is valid. And it therefore held that the 31(4) proviso is not mandatory, and this requirement of receiving CCI approval before COC approves the resolution plan is not strict in law. This was reiterated by some further decisions of the NCLAT, specifically the ones mentioned on the slide, Vishal Vijay and Makalu Trading. Then in Bank of Maharashtra versus Videocon Industries, NCLAT took a contrary stand. NCLAT rejected a resolution plan partly because of failure in obtaining CCI's approval before the COC had approved the resolution plan. This led to confusion on whether the provision of Proviso 231(4) is mandatory or not, and whether CCI approvals can be received after COC approvals, and if they are received before the NCLT approval of a resolution plan, whether that's still valid for the IBC. And then I'll now hand over to Kritika, who will discuss in detail the INSCO versus Girish Sriram case.
Good afternoon, everyone. So I'm going to quickly go through the facts of the case of Insco versus Girish Sriram Janeja. The corporate debtor here was a dominant player in the glass packaging industry, and 2 resolution applicants had submitted their resolution plans before the COC. One was AGI Greenpack and the other was Insco. At the time of voting upon the resolution plan, Insco's plan had already received CCI approval, but AGI's plan had no CCI approval. AGI only managed to get conditional approval later after the COC had already voted upon the plans. Now, here it was easier for CCI to actually get approval because, here it was easier for Insco to actually get approval because Insco did not operate in the same market as the corporate debtor, and it qualified for a simple approval mechanism known as the green channel mechanism. However, AGI did operate in the same market as the corporate debtor, and thus it was subject to more stringent scrutiny by the CCI. After the COC voted on the plans, COC approved AGI's resolution plan, even though it did not have CCI approval. But however, AGI did subsequently go on to get CCI approval, but this was a conditional one based on AGI's divestment in one of the corporate debtors' plants. Now, Insco was aggrieved by this, and it then challenged this before the NCLT and then the NCLAT, and both of which upheld in AGI's resolution plan. NCLAT also held that the timelines under IBC and the Competition Act actually conflict, and therefore the requirement under Section 31(4) was not mandatory, it was only directory. Insco appealed these NCLAT orders before the Supreme Court. Aishwarya, can you go on to the next slide?
Yeah, I have. Has it reflected?
Yeah, it is. It is. Now here, the Supreme Court allowed the appeal and set aside the orders of the NCLAT. It held that AGI's resolution plan and the COC's approval of the same was unsustainable. And it also directed that Insco's plan be reconsidered along with plans of other resolution applicants that had the requisite CCI approval before on the date the COC had voted on the resolution plans. Now, it relied on various statutory provisions and reasoning to come to this conclusion. First was a literal interpretation of Section 31(4). The Supreme Court said that the law is unambiguous. It uses the term shall, and it is very clear that the legislative intent was to treat this provision as mandatory. And because it is so clear that this provision is mandatory, the legislative intent also shows that it intended to treat CCI approvals on a different footing than other regulatory approvals. And this is justified because CCI in a growing economy, especially in India, plays a crucial role in ensuring that restructuring in insolvency does not cause any adverse effect on competition in the market. In relation to timelines, it also held that there are no conflicts between the timelines under the IBC and the Competition Act. This is because while the Competition Act does stipulate a 210-day timeline for approval of combinations by the CCI, in practice, CCI has approved most combinations within 120 days. And there was a 2003 amendment to the Competition Act where this 210-day timeline was reduced to 150 days. And hence, the timelines are consistent and there is no conflict between the two statutes. The NCLAT in one of its judgments also relied on the SR Steel case, as my colleague Aishwarya had said, the ArcelorMittal judgment. And the Supreme Court actually distinguished that judgment from this judgment and said that no, because in that case CRP had commenced before the insertion of proviso to Section 31(4), that the facts of those cases are not applicable to this case. The Supreme Court also noted that conditional approvals are very risky, and sometimes there are risks in the market that have already taken place before these conditional measures are fully implemented. And then if remedies are resorted to later to correct these issues, then they in most cases will not be sufficient to correct these issues that have already arisen. And it also said that CCI's conditional approval was not in accordance with the law because it was conditional and it did not really respect the time-bound nature of the IBC. Ashwina, next, please. Yeah. Okay. Yeah. So now there are two ways of looking at this. One view is that the Supreme Court was right. Competition law is extremely important for the economy and must be strictly enforced. However, there is another view that the Supreme Court's conclusion in this judgment actually
sorry, your time is up. I would ask you to wrap it up quickly.
Yeah, sure. Okay. So I'm just going to come to that. There are two opposing views, and the IBC bill in 2025 has actually taken the second view and has proposed an amendment to Section 31, subclause 4, which says that now CCI approvals are necessary. You can get the resolution applicant can get CCI approval before the plan is submitted to the NCLT, and not necessarily before the COC votes on the plan. This is a welcome amendment. However, there are certain proposals that we have. Ashwina, next slide, please. Yeah. First is that it may consider codifying ILC's recommendation that the CCI approve combinations within 30 days, and in case it fails, and there's a deemed approval mechanism. We have also seen that even in the US, insolvency mergers do have truncated timelines for review and approval, as opposed to non-distressed mergers. Secondly, irrespective of any timelines on the law, the CCI should conduct rigorous reviews of proposed combinations, because combinations, even if they're taking place under the IBC and for the benefit of the distressed company, should not cause any adverse effects on the market. Second, Section 196 of the IBC allows IBBI to enter into memorandum of understanding with other regulators, and IBBI may consider using this to actually spread knowledge of the systemic impacts and the macroeconomic effects of insolvency, so that regulators may better understand their role in this system. And lastly, and the most important, in the INSCO case, the Supreme Court had highlighted how various stakeholders in the process had failed to discharge their interdependent duties. The success of the IBC is based on timeliness and on stakeholders actually performing their duties properly and in alignment with the law. Here, the RP had given permission to the resolution applicants to get approval at a later stage. The COC voted on a plan that did not have CCI approval. And there were various other, and in fact, the CCI also gave conditional approval, which was not in alignment with the law. And hence, we need to see a behavioral change among stakeholders for the law to actually be successful. Thank you.
Thank you. Am I audible, ma'am?
Yes, you are, ma'am. Yes.
Yeah, actually, because of this case, I mean, the implications of this case, if you take, don't you think there is a timeline for CCI to complete the proceedings, and the weight which the corporates have to wait, the cost, time, and all the risks is being taken till the approval of CCI, they have to wait. So don't you think there is a big timeline gap is there, delay is there in these proceedings? This resolution process is taking time now.
Ma'am, yes, we agree that there are, of course, like, as my colleague also highlighted, regulatory approvals take a lot of time, and there are, of course, a lot of delays in implementation as well. Even in this,
how better that can be simplified? That see, in your paper you have highlighted this case, and you have detailed on what are the positives, pros, cons of this judgment, everything. So as a paper presenter, I would like to know, what is your view on how to simplify this delay? Because the idea behind IBC is to reduce all the delays. Bringing such a code itself was to reduce. So now we are including CCI, the prior approval, so that's mandatory. So when it comes, any suggestion in your paper?
Yes, Kritika, if I may just. One of the suggestions we've made in our paper is that there should be a 30-day timeline for CCI to grant regulatory approvals. And where there is when this timeline is not met, then it should be considered a deemed approval. And we're basing this on the Competition Law Review Committee's recommendation when they were designing the green channel mechanism for CCI approvals. Even while designing the green channel mechanism, one of the discussions of the Competition Law Review Committee is that IBC cases could be included within this green channel mechanism, which has not happened. Similar recommendations were also made by the Insolvency Law Committee of giving a 30-day timeline for CCI approvals. So we completely agree, ma'am, and that's why one of our suggestions is for a codified timeline with a repercussion so that the timeline is not interpreted as directory.
Okay, okay.
So my simple question is this, that out of 8,000 cases which are there with IBC, under IBC, around 1,200 have been approved, right? So out of that 1,200, any hurdles have been created because of CCI approval? Because this empirical data that will be helpful if it is presented in your paper. That is what. Yeah. Have you research on that? How, because all of these are large cases. CCI approval means they are all big cases.
Big cases.
Yeah, it cannot be small because we know that. And besides, financial feasibility and viability gets impacted a lot if the CCI approval is not in time. It impacts all the, and how does COC take this into consideration? When a plan is put up for approval, when they receive the application, how do they view this particular angle? That anything you can say about this?
So we actually took a very theoretical approach to our paper, but we take your point. I think we will look at cases where, smaller cases also where CCI has sort of, has granted approvals or not granted approvals, and actually see what were the grounds for this. But when it comes to really COC's role, one of the ways to look at it is that sure, CCI approval is more like it's a requirement in law. So that is for NCLT to see. The COC's role is limited to understanding whether the plan is commercially viable or not. And the repercussions of whether a plan actually is in accordance with the law only arises before the NCLT. So that is really for the NCLT to see. But the COC is more concerned whether the resolution applicant will be able to turn around the corporate debtor.
Yeah, my point is that only there are suppose 4 resolution applicants, and out of that 1 or 2 are able are only covered under for CCI approval. Maybe 1 or other 2 are not covered. Then what happens? You get my point. See, if there are 4 resolution applicants, 2 are not covered under CCI provision, and 2 are covered. Then what happens? So this type of thing can be more research. That's the only suggestion. Overall, it's a good paper. That's fantastic. But more data, more case studies are required, because we are relying here only on one case. And Supreme Court has decided, and it is the right decision, that 30 days CCI approval is required. But the problem is that we don't achieve objective of IBC, because in 30 days nothing is going to happen. We know 180 days it doesn't happen, 270 days it doesn't happen, 330 days it doesn't happen. The timelines are 700 plus days. So this type of approval are very critical, but that more data can be analyzed, and then we can, for policy making, we can suggest. That's what is my thought.
Sure. So just one point, we take your point on data. We'll try to embellish that in our paper as well. Just on the issue of approvals before COC approval, though, we don't think that the CCI approval is materially different from a lot of other approvals that will be critical to rescue of the corporate debtor, which are still availed after the NCLT approval. The only distinction is created for this CCI approval, which we understand is because it is critical and is necessary in most cases. However, we do think that requiring this before COC approval becomes very, very stringent on the timelines and kind of creates a hold-up. So as much as we agree that procedurally COC should be able to see whether CCI approval is granted before the approval.
Excuse me, ma'am. Sorry to interrupt you, but your overall time is up.
Okay, sure.
Thank you, ma'am. Thank you.
Thank you.
Thanking all the presenters, now I request Professor Dr. R. Harita Devi ji to conclude the gathering with her insightful words.
Thank you. At the outset, let me thank Nalsar for inviting me. It's interesting to see some papers. Actually, I saw only 2, but still we could get different views on IBC code. In fact, it was a very ambitious legislation, I would say, because from the previous Companies Act 2013, the winding up itself was years together. So that created a lot of trouble both to the creditors or companies or corporates or whatever. Everybody was in trouble because we have heard that some companies will be locked for years. Nobody will know what's happening. But inside, when you look into, we will understand that they are under in winding a procedure. So that was too big to handle and so many were suffering. So to avoid that only, this ambitious legislation of Insolvency and Bankruptcy Code was brought. But practically, when we think, maybe I'm not an expert on it, but still the delays in resolution process is still pending. That's what I feel. Just like it's pending in some other court, now it is pending before these bodies. So that delays, especially at admission stage due to objections, litigations, procedural bottlenecks, etc., are still there. So that has to be taken into consideration. And paper presenters like you or youngsters like you or people working in this field, ICSI especially, like have to think of some procedure or some process where this delays can be avoided. Because especially judiciary itself, lawyers, we think every time why so many cases are pending for so many years. Likewise, these proceedings are also pending. Then I feel there are capacity constraints and institutional weaknesses also, because NCLT and appellate tribunal, etc., and all are already overburdened with so many cases. Plus now they have to handle this after IBC code has come. So that subject matter expertise are also lacking. Because when you take Competition Commission of India, earlier appellate tribunal was there. Now that appellate cases are also coming to NCLT. So what happens is, whether they are really competent or how far these cases are going to be taken care of, etc., is also a problem. And cases, complex litigation and judicial review with fighting with huge corporates. So it's always, that is a matter where the objections, what all can be made, what are the eligibility conditions, etc., and conflicts with other laws like environmental, labor. That's why ESG is here always. So what about that field, all that complex situation of connecting with other laws, that is also still, I would say it is a challenge. And fraudulent filings once again, so that also takes away the time. And despite being recognized as financial creditors, the operational creditors' rights, when we look into, they are also still in the, I would say, based on some court decisions, and it is not finalized and still standing there. And MSMEs, when it comes to small companies, whether they are really benefited out of it is still a question, I would say. Because as the previous paper presenter was talking about the CCI approval, when we read competition law, CCI approval is only for larger companies, not for all companies, right? So again, the mismatch of how MSMEs, because India is one country where we are benefited out of MSMEs also, economy also. So whether MSMEs are really benefited out of this code, whether the proceedings are quick for them, because for them time matters, not like large corporates. Maybe the large corporates may be able to withstand this delay, but MSMEs might not. So because of that, that is also again a big challenge, I would say. And still some sections, there are ambiguities and there are meanings to be defined properly, still pending is there. So on the whole, for paper presenters or any students and anybody who's so many paper presenters are here, a small suggestion would be, whenever you take a paper for or any subject for paper presentation, I would suggest take a very, very small topic. Maybe like I said, one definition. Maybe on that you can develop your paper, and your paper should definitely have a specific suggestion. This is very, very important, because papers cannot, we can't just like that suggest and say. For example, the previous paper which was presented now, historically it has been evolved, I mean correctly taken. Actually, it is a very good paper for future researchers, because you have given the timeline of what happened, how IBC came, everything you have stated. But your paper, what it is contributing, is lacking there. So whenever your paper presenting, please make it a point that you have a specific issue to take, and for that issue, what is your suggestion? A practical suggestion. So that will take your paper a long way. And as sir was mentioning, for policy making and the conferences like this, we can give suggestions to policy making also. So your paper will be taken to greater heights. Your suggestions will be taken to greater heights. Thank you for this opportunity. Thank you.
Thank you so much for your incredibly informative summarization and guiding young students and presenters' minds through and through, ma'am. Now, I would like to call upon Company Secretary Rajesh sir to present a few tokens of appreciation to Mr. Jayesh Sangrajka ji. Thank you, sir. Now, I would like to call upon Vinay Nagaonkar, sir, to present a few tokens of our gratitude to Professor Dr. R. Harita Devi ji. Thank you so much, sir. Now, thanking everyone for your cooperation, we will have a brief sponsorial presentation for 5 minutes, which will be followed by lunch. I would thank both the panelists for gracing us today.
I represent Edify brand, which is into K-12 school franchising. We have 35 K-12 school campuses pan-India, and we have 55 preschools. So I was just trying to connect with people that if you're looking for some deliverables into the society where you feel that you can connect with modern education, we are the right brand that you can suggest or probably invest in. We have pan-India presence for 35 schools, which I'm sure might be able to display. Rest, if you have any connections that you feel like connecting, you can connect with Mr. Sheshu or me. We are just outside. You guys have been seeing us.
I request all the participants to just stay for 4 to 5 minutes more.
So prerequisites for our schools is going to be, if you're looking for a budget of around 10 lakhs, you can opt for a preschool at a very small space of 2,500 square feet. If you're looking for an investment in between to 5 to 15 CR, that is where you can invest in a proper K-12 school. You can have a minimum land of 2 acres, which is as per the CBSE norm. It can be rented, it can be leased, it can be yours, it can be anything however you want it to be. Our services will include your entire operational support from our end, making your school to be automated. We do all recruitments, all trainings. We have our own curriculum, which is 3C, that talks about character, competence, and content. So as every child is a different character, they have different competencies, hence their content has to be different. This is what we are trying to promote. We come from our parent company, which is DRS Group, Agarwal Packers and Movers, if you have heard of. We have been into franchising business for 16 years, and we have our very own renowned campus, which is DRS IS. That is an IB residential school here in Hyderabad itself. So coming back to the recruitment, the deliverables that we are going to give as a brand is all your ERP support, anything and everything. We are at your back and call for the support that you need. That is pretty much what we cover into a K-12 franchising thing. I will not take much of your time. I totally understand you guys want to proceed for lunch. We can have just your numbers or details that we can forward you these details, and you please can proceed with the lunch, and I'll get these PPT mailed to you. Thank you, everyone.
Everyone can now proceed for lunch near the Thinking Man statue.
You have the profile ready, I'll give it out. You can open it up. हाँ, चलेगा. Just put it over here. What's happening? I didn't do.
Good afternoon.
I'll take the honors of inviting Mr. Professor Anil Kumar Rai, sir. And sir, please come, sir. Dr. C.S. A.G. Ravindra Reddy, sir. I humbly request B. Narasimhan, sir, immediate past president of ICSI, to please give sapling to A.G. Ravindranath, sir. Now I request CS GSL and Gupta Garu, immediate past chairman of ICSI Hyderabad chapter, to please give sapling to Professor Anil Kumar Rai Garu. Okay. Now I request Sadhana to introduce the panelists.
Good afternoon, everyone. We are deeply honored here to have us with us today, an accomplished panel of experts. Firstly, we are delighted to welcome Professor Anil Kumar Rai, Professor of Law at NLU Delhi, whose expertise spans banking, corporate, and insurance law. With an illustrious career across premier institutions like NLS Bangalore and Delhi University, he also brings rich professional experience as former partner of Luthra offices. Among his scholarly contributions is his authorship of the banking law section of the Annual Survey of Law of Indian Law, 2013. We are equally pleased to welcome Mr. A.G. Ravichandranath Reddy, a qualified company secretary, insolvency professional, and corporate consultant with over 2 decades of experience in corporate and economics law. He has held senior management roles practicing as company secretary for 15 years and continues to shape corporate practice as the founder and chairman of AGR Advisors LLP. He also serves on the board of leading companies such as Ramki Infrastructure Limited, Vijayanagar Sagar Private Limited, and Rockwell Industries Limited. Thank you, sir, for honoring us with your presence today.
Now I request Professor Anil Kumar Rai, sir, to start with the opening remarks.
Yeah, hello. I thought that my remarks would be at the end of it, okay, instead of, but yeah, it feels honored to be a part of, there are 3 papers on the bankruptcy code which are there. Okay. I don't have much to say with regard to it, because on the papers which is, because I don't have, after I come to know about the paper, on whatever the presentation is, I would be able to. But one thing I would like to say is, see, people go by the assumption, this is something which I come across generally with most people, is it's a crime to become a bankrupt, okay. There is an assumption with regard to it that the person concerned who has become a bankrupt, he has cheated someone and siphoned off the money, and you equate a bankrupt with also what we can call a willful defaulter. The amendment to bankruptcy code, which was done in 2018, that is section 229A capital 3, goes by the 29AC, sorry, goes by that particular assumption that a group which has a bankrupt in its midst is somehow different from any other group which has not been a bank, in which the bankruptcy does not occur. Let us be, when you approach the subject, I think it would be very, very much appropriate. We take into account that it takes a person a lot of guts and optimism for him to start a business. 95% of, it has been proved, calculated, roughly 95% of the restaurants goes out of business. Only 5% of them survive. So the person who is a bankrupt is not necessarily a person who is a cheat. There has been luck which has been against him. There might be circumstances which are beyond him. And in some cases, like in the case of Vidarbha Industries, it might be the government which does not pay him what are his dues. Okay. So we have to factor those particular facts in account, that it's not necessarily his fault that he has become a bank. Okay. Bankruptcy code is, we have to understand that in the 18th century Britain, there was no concept of bankruptcy. It was insolvency laws and bankruptcy laws were brought in the early 19th century. The person concerned, would stay in the jail until and unless he was able to pay up. That's why, though by law company was prohibited in Britain and England, they still found a way to go about it to start companies. And bankruptcy and the company law which came up around the same time, these are at the heart of our capitalist system. That is, allow a person to take risks, to innovate, and only after he or she is allowed to take risk and innovate, can we come across and progress. Okay. Historically, progress has been 1% economic growth per annum at the max. Okay. It is after these two innovations, legal innovations of bankruptcy code and the companies, that the growth rate has suddenly increased. So over the last 2 centuries, we have found a growth rate on an average, even in developed economies, a 2.5% or 3% growth rate is normal. And in developing countries, the growth rate is higher. That is, we expect 5%, 6%, whatever. Now, this is because we have allowed for a room for innovation. Okay, that's all I would just say. Okay.
So we'll go with the presentation part. First, we'll be calling upon Shruti Singhi, an analysis, title of the paper, an analysis of the corporate insolvency regime in India for technology-driven businesses. As time is pressing, please restrict to 10 to 12 minutes.
Thank you.
So good afternoon. I'm Shruti Singhi. This is my topic. I'll be presenting regarding the insolvency regime in digital businesses in India. So the paper begins by addressing the contextual evolution of the regime since independence until the implementation of the 2016 IBC. The paper then considers official reports and assesses how the new law has worked and considers the reports and suggestions of IBBI and other committees. The paper then follows with a brief review of the amendments of 2025, as well as the insolvency frameworks in countries like USA, UK, and Singapore. Finally, the paper considers projections and potentials of digital businesses and considers two case laws in this context, and concludes with some recommendations. So starting with the post-independence regime of the Indian economy, most production and distribution was state-owned, and therefore the Companies Act and Industrial Development Regulation were found to be sufficient for regulating these businesses. In 1991, due to the economic crisis owing to the balance of payment crisis and high public debt, the country was at the brink of insolvency. Therefore, policies favoring state-owned industries saw a shift as the trade liberalized and a private sector emerged. Creditor approach evolved, and laws facilitating debt recovery were established. So in 2001, the RBI RBI introduced some restructuring measures, which was a response to the US market crash in 2001 due to the Twin Towers. Finally, in 2014, to mitigate the 2008 recession, banks had accumulated significant debt and NPAs, and had accumulated a lot of risk. So in 2015, the extent of the banking crisis was brought to light when forbearances were withdrawn. It was in this response to the banking crisis that IBC was implemented. So since its implementation, as you can see, 8,308 companies have been admitted, but the recovery remains low at 33%. It is important, however, to consider that the early cases were a response to the banking crisis, and a lot of which has seen significant shift and resolution since its implementation. So the regulators have recommended pertinent measures to strengthen the Indian corporate structure since then. Some of the laws, some of these suggestions have been incorporated in the 2025 amendments. Most notably, the creditor initiated corporate insolvency processes, and the recognition of the need for a cross-border insolvency regime has been noted. Finally, countries like it is also important to note that countries like UK, USA, and Singapore favor a rescue-focused approach, which is to say that the rescue of the debtors is a foremost concern in these jurisdictions frameworks. But Chapter 11 and 15 of the US framework, for instance, is the debtor remains in control during the resolution, and the debtor in fact proposes the resolution. In UK and Singapore, the framework provides for restructuring and mediation measures, which too are debtor focused in terms of rescuing the debtor. So in this context, now it will be beneficial to consider the businesses driven by technology. So going on to the potential of these businesses, there was a report of the JP Morgan in 2022, which has projected these markets to be worth trillions of dollars, and they focus heavily on digital gaming, online gaming, and trade in cryptocurrencies. Now, it is very pertinent to note that the metaverse was established as a decentralized platform, and while some countries have regulated, while different countries have different approaches to the regulation of the metaverse, India has yet to determine its stance towards such regulation. So the paper, anyway, going on, the paper looks at two case laws, one of Byju's and the other one of WazirX. These are two Indian companies. Byju's was an edtech company, is an edtech company. It was initially admitted into CIRP going to debts owed to BCCI, which was later settled and withdrawn. There was a landmark case law regarding this where the Glass Trust of India had contested this withdrawal, and the amendment also speaks to it of 2025. The following that, the Glass Trust was removed from the COC, but now has been reconstituted in the COC. So as you can see, there is a lot of disparities in the treatment of. So Glass Trust is a US-based lender for Byju's. Going on, Bazidex is a cryptocurrency platform. It had availed insolvency support in Singapore following a cyber security breach which compromised 45% of the exchange funds. So there was a resolution plan which was voted upon and passed, but the Singapore court had rejected it. So there was a following amendment to the resolution plan which was voted upon. However, it is pending because a parallel proceeding regarding the ownership dispute of the platform is pending before Delhi High Court. So from the mentioned cases, it is evident that the present framework is lacking in three pertinent areas. Considering the speed at which these digital businesses have been evolving and the cyber security risks owing to which they are expected to respond to, it is pertinent that swiftness of adjudication is ensured in the sense of building institutional and bureaucratic strengths in the system. So to facilitate early resolution and fast resolution of these companies. Cross-border cooperation and coordination is also very important, as we saw in the case of Byju's, where the treatment of a US-based company was in question. Furthermore, there is a need for a data rescue focus, data rescue approach to the Indian insolvency law, which is presently lacking. In the sense that the debtor is not given an opportunity to resolve his own company on his own, and is required to avail services of officers and creditors. So apart from these three, there are also demonstrable need for a framework for early identification of stressed companies. There's a need for a formal framework for early identification of stressed companies and a formal structure for pre-insolvency mediations. There is also need for sector specialists in terms of RPs, which would deal with these kind of companies and the valuation of these kind of companies. Finally, there is a need to build knowledge and understanding in the context of the regulatory approach to the metaverse, considering the diversity in the in approach that countries across the world have taken. It is also pertinent to note that the regulatory framework is one of the most important considerations in determining the volatility of these platforms, especially considering the approach of the Indian legislations, which has been blanket bans earlier in the cryptocurrency, and presently the very controversial gaming incentivized gaming ban. So there is there is a very dire need for regulation, for establishing the regulation of these digital spaces and the businesses that will go from that. So thank you. That was my presentation. I would appreciate any questions.
Panelists, any questions to the presenter?
It's quite interesting to note that she was talking to the debtors. Quite interesting to note that she's talking about the debtor rescue approach. It's a really interesting point. I just want to know what is your suggestion on that? How do you want to IBC to help the debtors?
So it would help help if the IBC or another formal framework is established where a debtor is given an opportunity to bring itself out of its debt. For instance, in the Chapter 11 framework of the US insolvency framework, the debtor is given an opportunity to present a resolution plan, which is then voted upon and considered by the courts, and then the company the resolution goes on from there. So or otherwise UK and Singapore approaches where there is a out of court arbitration or mediations in UK and a restructuring mechanism in Singapore, which could pose as good examples for the IBC for the insolvency regime in India to consider.
In fact, now even in Indian IBC, there was no opportunity for the debtors once the creditors file a case when 1 crore and above is due in NCLT, and they're out of the picture. But MSME, in fact, the amendment has been brought in for MSMEs, the promoters or debtor company can still be possible for them to take back the assets and run the company, provided they comply some of the conditions. This is one of the things which have been introduced recently, so which is for MSME. Otherwise, the moment NCLT admits petition, the debtor is out of the picture. He is helpless. He only sits in the COC meetings only to observe the proceedings. He doesn't have any voting, anything. But I have seen many debtor companies where they, corporate debtors, where they go back to the courts to litigate the matter so that they gain time. So unfortunately in India, even though IBC was meant to resolve the issues within 180 days, but it's taking 2 years, 3 years also. This is a very, very unfortunate situation at the ground level. It's all because of the litigation. And thanks to our ingenuity of our lawyers at a different level from NCLT to High Court to Supreme Court, though many judgments are there that no one should interfere in the matter except NCLT and NCLAT, but still High Courts are interfering in many matters and giving a stay, giving a direction, so making it sub judice. You know, all as a lawyers, the moment matter is sub judice in one court, all the other proceedings in elsewhere is also stopped. So these are the techniques used by the professionals who are this, which is not right or wrong. We can debate separately, but that's our process going on. So excellent. I think that's a good point from your side.
Thank you, sir.
Just, I mean, you refer to this bijus and but the issues you never touched upon. Okay, so bijus, one issue is with regard to where the person himself who has applied for the insolvency resolution process, whether he can withdraw it after he is satisfied. Third parties, can they object to the withdrawal of it? I mean, the person who has initiated the insolvency resolution, BCCI initiated it.
Right, sir. And
BCCI was paid off by Biju.
Yes.
Okay.
And then Glass Trust
Glass
objected
Trust
to the
objected,
withdrawal.
but Glass Trust was rejected at the first stage.
Yes, now it's admitted though, as of January.
But the person who has initiated, can he withdraw it, or he loses the process?
Right. So this is a concern that was that the Supreme Court judgment had touched upon, and I think the new amendment also has made some clarifications regarding the withdrawal of proceedings after the constitution of the COC. So I think the 2025 amendment would be a very good next step, even in terms of the timeline for the resolution of companies, because as of now it is a very slow process, and that is not a that is not a timeline which businesses like those in the digital space, which are very volatile and very innovative in that respect and need some space to grow, would be able to work in. So I think the 2025 amendment would give a lot of clarity in that regards.
No, I mean, the issue is still a very important. The person concerned who is the initiator and who is authorized to initiate the insolvency process.
Right, sir.
Once he is satisfied, will the process still go through or it won't go through? Second, with regard to Wazir X, you see,
So it did go through it.
Not this, because the court found it a bit odd with regard to that the someone else paid it and he becomes a creditor and he withdraws it.
Right.
Okay.
So in my opinion, it would also be incorrect, because then a fresh proceeding would be in order when another creditor deems it fit that he has been wronged in that sense, and that proceeding I don't believe would be under the IBC, because his claim was that that BCCI was paid from him money which was owed to him. So in that respect, it is a bit in the gray area, but I stand by my opinion that it would not be permitted in the normal course of things.
Second thing with regard to Wazir X, because Wazir X issue came up because it's Wazir X itself which initiated the proceedings, I believe.
Yes, sir. Yes, sir. It was due to a cyber security breach, because of which 45% of the currencies of the funds were compromised, because of which they undertook a restructuring proceeding before the Singapore courts. Also, because it is very very important to note that such a structure is not permitted under the Indian laws, because if a company were to go in CIRP voluntarily, there would still be a court officer. The management of the company would then in that case shift.
Now, there is it's a problem with regard to Wazir X is that the securities which were stolen did not belong to Wazir X. It belonged to others. Okay, so
Yes,
Wazir X was liable
so
for
it was
those.
a platform. So
It
that
was
is another important
issue.
important consideration, that financial institutions cannot approach the courts under IBC. So in that case, because the nature of cryptocurrencies is still in that sense not finally established, it would also be difficult for that platform to avail reliefs in India under this structure.
See, in a warehouse, if your goods are stolen, okay, there can't be a resolution with regard to. That's what it's. The Xerox was a warehouse, essentially.
Yes, sir. Yes, sir. But I agree to your point, sir. The object behind referring to that case law was the complexity. What was to demonstrate the complexity involved in such businesses, and in such a case where the company evidently needs some time and space to grow by itself, is willing to grow by itself, there should be a structure in place to facilitate that growth under the Indian laws.
Thank you.
Thank you, sir. Thank you, sir.
Next, we have the presenter, Dr. Pooja Srivastav, on the topic competition, IBC interface in distress M&A and sequencing conditionality and regulatory coordination of the Supreme Court's AGI Greenback HAG rule.
Good afternoon. Good afternoon. Am I audible? My screen is also visible.
Yes, ma'am, it's visible.
So, very good afternoon to all the panelists and all the stakeholders present here. I'm Dr. Pooja Shrivastava. My topic is competition and insolvency bankruptcy code interface in distressed merger and acquisition, sequencing conditionality, and regulatory coordination after the Supreme Court judgment AGI Greenback HNG rule.
Make it full screen. Presentation is not full screen. Can you please make it full screen and proceed?
It is full screen, sir. From my side, it is full screen.
Yeah, you can continue.
So here It is divided, the entire presentation is divided in 8 parts, where firstly I will discuss about the overview, the introduction, then the case history and the ruling issued by, given by Supreme Court, then its implication in market, and then policy recommendation. The interface between insolvency law and competition law has emerged as one of the most significant and debated issues in India's corporate restructuring landscape. On one hand, Insolvency and Bankruptcy Code is designed to consolidate insolvency laws and value maximization within 330 days. On the other hand, Competition Act 2002 has enacted to safeguard, anti-competitive, to safeguard market structure, preventing any merger which can cause anti-competitive effect in the market. The conflict arises when a resolution plan under the IBC qualifies a combination within the meaning of Section 5 of the Competition Act. Parliament has attempted to introduce and to issue one clarity by the amendment by introducing one proviso in 2018 in Section 31, subsection 4, which clearly states that where a resolution plan involves a combination, the resolution applicant must secure approval of Competition Commission of India before the Committee of Creditor consider or approve the plan.
Ma'am, if you were changing the slides, we're not able to view the same.
Yes, I'm trying to change my slide, but it is not. So can I continue without slide or without changing the slide?
Yes, ma'am, please.
The case background. The most prominent controversy on the issue arose in the insolvency proceeding of Hindustan National Glass, India's largest glass container manufacturer. When the company entered an insolvency proceeding in 2021 October, two serious bidders emerged. The first was Independent Sugar Corporation and second was AGI Greenpack, who itself a major player in the glass industry. In October 2022, Committee of Creditors has approved the plan with 98% of majority. Even till the CCI had not given clearance to AGI plan. In fact, AGI's first form which has been submitted has been rejected by CCI, and later on the second form has been submitted in November 22 and which has been approved and passed by CCI in March 2023. But this clearance from CCI came just for the structural remedy because the plan has already been approved. Despite this, both National Company Law Tribunal and Company Law Appellate Tribunal has upheld the plan, reasoning that CCI approval was mandatory, yet the requirement of timing was merely directory. Here they are talking, yes. So that is the background, that is the introduction of the case. Now, Supreme Court has given the judgment with 2:1 ratio, where Justice Rastogi has given his dissenting opinion. In this case, Supreme Court has addressed the issue related to it and has gone with the literal rule of interpretation, where it has said, where it was written in the statutory, in act it is written that prior to the approval, before the Committee of Creditor, which has left no room of treating the requirement as merely directory, means the approval of CCI, and that is before the approval, before the plan will pass by the Committee of Creditor. Yet, The court has rejected the argument by saying that this thing sequencing would jeopardize the IBC timeline, pointing instead of empirical data shows that CCI reviewed the matter in 21 working days. And also by 2023 amendment, the timeline has been decreased, and now not in 210 days, but in 150 days, they have to resolve, they have to finalize the entire process. The court insisted that creditor must vote on final plan and should not consider the plan which has not been approved by the CCI and has not been cleared by CCI. The practical implication, if we will talk about the practical implication, the ruling has significant consequence for all the participants in insolvency ecosystem. For resolution applicants, the decision means that they must prepare remedy-ready plan with potential diversities, behavior commitments factored into their valuation and strategy at early stage. They cannot rely on the post-clearance and conditional approval. Then for resolution professional also must take a more proactive role in harmonizing the insolvency and competition process. The request for resolution plan must explicitly require bidder to obtain CCI clearance before committee of creditors voting. The committee of creditors too will have to adopt its approach. It is no longer sufficient to evaluate plans solely on the basis of financial recovery. Creditor must also assess regulatory feasibility and the execution of risk associated with securing CCI clearance. It has certain implication. The judgment has certain implication. As I already mentioned, that Justice Rastogi has given dissenting opinion, and he said that he argued that rigid sequencing could frustrate the objective of IBC by delaying resolution process. But by 2:1 ratio, it has been approved that the prior approval of CCI is also required, also mandatory. Now it's market insight, market implication, if we will discuss. So here, so implication that it has influenced the attractiveness and distress assets. It has India's approach now by that judgment. India's approach is aligned with international rules, because in EU and in United States both, it is not allowed to all the companies. It is only allowed to those who are failing firms, those who the European Union basically applies this principle in case of failing firms, defense only, in a strict condition, means requiring proof that the firm would exit the market and there is no anti-competitive purchase or exist. Similarly, in United States, allow the similar kind of approach in merger guidelines, where the insolvency does not override competition security. So by that judgment now, India's rule regulation will also align with the international rule and regulation. Now here are certain recommendations. Certain recommendation could be given for all the stakeholders, for all those who are involved in the insolvency proceeding. This article suggests that several reforms to operationalize the court's mandate while preserving the efficiency of insolvency proceeding. First, Parliament could codify the sequencing requirement explicitly in IBC to reform and residual scope for litigation. At the same time, the government must resist pressure to overcorrect by shifting CCI approval after committee of creditors voting, as such a move would undermine creditor decision making. Second, CCI should develop fast-track procedure for insolvency drive-in combination, similar to those simplified procedure in European Union and in United States, which will minimize overlap Third suggestion, that institutional coordination. There should be coordination between CCI and Insolvency and Bankruptcy Board. Resolution professional should notify, should timely communicate to both the institution, to CCI and Insolvency Board simultaneously. And finally, India requires a robust remedy monitoring framework. Conditional approval will remain a part. In 1 second, in 1 minute, I will conclude. Finally, India requires a robust remedy monitoring framework. Conditional approval will remain a part of merger control, but the appointment of independent trustee is strictly timeline for diversity and compliance reporting. I will conclude by saying that if it is aligned, then it could expedite the procedure, and where there will no overlapping from any institute. Thank you very much.
Panelists, any question to the presenter?
Dr. Puja, I really appreciate your detailed analysis on a very complex situation. So now, as you are aware, that IBC clearly says that it is superior to all other laws.
Yes, yes.
When you have income tax, provident fund, so many laws. So we don't give. So they have any claim, they should come and present before the COC or NCLT. So when that situation is there, why not amend the IBC in such a way that CCA also subservient to IBC and they should represent before the NCLT? Is it possible? I mean, what is your comment on that?
So, in my opinion, amendment is not required in so many provision. Yet, sequencing is required, and because of overlap, all the problems which we are facing in insolvency process. But amendment in entire code is not required, in my opinion.
Thank you.
Thank you, sir.
Before concluding, I would request Mr. Giri Smitra to give memento to the panelist, Professor Anil Kumar Rai, sir. I'm sorry. I would request A.G. Ravindra sir to conclude. Sorry, my bad.
Yeah. Sorry. Thank you. I think you have to wait for another 3-4 minutes.
We have time, sir. Sorry. Yeah.
Really, it's a great pleasure for me to be on this dais along with Professor Anil Garu, and to also address all of you. The paper presenters, both of them have done a great job. A lot of homework they have done, but because of the paucity of time, I don't think they have presented in full to their satisfaction. But I could go through the papers, what they have given. So we should really appreciate for their efforts to make it. Both situations are very complex and unique in their nature, because in my own experience, I don't think we have come across in Hyderabad a tech company coming for IBC. So a lot of digital assets are there, lean assets are there. Then how are you going to value it? Even it's very difficult today to value the platforms. So the expertise are not there, especially IRPs. As your suggestion, one of the things is IRP who is appointed for a tech company should have the knowledge. If the company is running, he should be able to run the company. So I mean, these are the complex issues which I think we need to evolve over a period of time. I don't think as of today, the present IRPs, as I know, are not geared up to the fullest extent. Maybe they can take their expert opinion, but still it's subjective in nature. So to that extent, I definitely appreciate the point you have highlighted for a tech company. And the judgment you have made in Baizu and Vazirex. Of course, Vazirex is definitely not within the context of the Indian IBC, but only the case law is pending before the High Court for who owns the platform. So platform ownership is to be decided. This is very difficult because no platform is not seen. It's all in the virtual form. How are they going to decide? It's a big question, technology point of view, they have to see. And in Baiju's, I have seen it's a very clear case, as sir also highlighted, that the person who has initiated, after some time he has withdrawn. In fact, when we all thought that it's not possible, but in fact, frankly speaking, even though IBC is clear in many ways, but thanks, or fortunately or unfortunately, the judiciary interpretation of law, definitely I think we all should take credit that we as advocates have made of course, along with other professionals also, CA and CS, made interpretation so different for the courts to analyze and then say a different verdicts, which gave a Pandora box, open up a Pandora box for many interpretations. That's the reason so many case laws have come. Now today, within a 9 years or 10 years of span time, now IBC is under change now. It's going to be massive modifications in 2025. So like your GST, the council used to give a lot of modifications and we used to amend. And now this is another case where IBC is also tweaked left, right, center by NCLT, NCLAT, High Court, Supreme Court. So because of that, there's a lot of confusion. Even we don't know really, a lot of High Courts are giving contrary to Supreme Court judgments also. So this is the confusing state for a lot of advocates and IRPs in this matter. Byju's is also a very classic case. Both cases, what you have referred, I really appreciate for your reference in this case, Shruti. I appreciate that. So then this coming back to Puja, I think is a very, very unique. And in fact, the competition laws is not applicable for the small size companies. It's only a company where it's a very, very big size of 1,000 crore and all that. So we come across very rarely here and there. In Hyderabad, we have seen only 1 or 2 cases where we have to go to CCI and get a prior consent. Because this is one of the area where IBC says that all laws are subservient to IBC. Whatever NCLT, whatever IBC is binding. But CCI is one thing which is not covered for obvious reasons, because the size company, monopolistic market should not be established. They want to have their own say whether it is monopoly situation is going to be created or not. So they want to have their say in that. But as Pooja rightly said, the sequential thing, because the successful applicant should not be suffered because of delay on the part of CCI. If they come under COC, as she rightly suggested, that COC should also review what CCI wants it. If they make that review properly at the COC level itself, I think things will make easy. And definitely the time frame is also given now, COC not more than 120 days, which is a good feature. But we know in India how to get over the timelines. We're all experts on that. Even though Civil Procedure Code is amended to make sure that the case should not be adjourned, but still we find different ways to get the adjournments and drag the matter for more than 2-3 years. So having said that, I think this is a very important aspect for the companies which are in a large size going for insolvency and trying to merger. So I think very clear case of critical inputs given by Pooja for all of us. It's a really, I feel that it's a trickling, mind trickling, brain trickling issue. We all should ponder again and again on this issue so that now we will get more information on this. So while I'll just conclude, thank you once again for the opportunity given for me to be one of the moderator. So it's really thank you once again. And my Institute of Company Secretaries who have requested me to come and join this along with Professor Anil. I'm really thankful for the Institute also and also Nalsar. Thank you very much.
Professor Anil, sir, you want to add anything?
Hey, what can I add? See, when IBC was enacted, all of us were thinking with regard to it that in 2-3 years, whatever was the backlog of it we would get rid of it. But when we saw it, what happened is, as it was followed as, there's few things which was quite evident to one's eyes, truncated. First thing which one could observe was the conflict as to what is the primary purpose of IBC. Okay. There were different people who were thinking on different lines. Okay. Perhaps the NCLT, it was, I think, I don't want to use the words of incompetence, but I think it was its own perspective with regard to it was treating the insolvency resolution professional. Some people thought that it should act like a government rule, that is, if someone has not submitted it in time, then if a resolution proposal is submitted, it should not take it up that particular. So what was the primary purpose of IBC? The primary thing about IBC is two. First of all is the company concerned should be, if it is possible, be rescued and made into a going concern. That is the enterprise which is there, that should be. And the second is the maximum benefit should be to the creditors. As much as possible, the creditors should get. Okay. So if the two purposes, okay. So as much as possible, the person concerned should get, the creditor should get it. Okay, so this is the, so if it doesn't make it, if a person has submitted a resolution process after a particular timeline, that is not a government rule book by which we should be, and it took all the way, we had to go up to the Supreme Court to get this particular thing resolved. Okay. The second thing which, I mean, the problem which happened with the IBC was with regard to the perception, and it was many of the resolution professionals had it, is if there is only one set of creditors who vote, then what is the purpose of, I mean, how should they vote? Okay. Now, this issue had always, see, it is many times is when a lawyer argues, I mean, and a non-lawyer who, I mean, someone who will think with regard to it. But in the case of when there is a property involved, will always be questions of equity. So if a person has got a voting right and someone who is in the same footing but he doesn't have an equity right, voting right, the questions of equity should be guiding the person concerned. That is, the voter has to take into also the account those who can't, who don't have the voting right. The prior rights is the mere fact that you have the voting. So and second thing with regard to equity is that those who are on the same boat should be treated equally. That is, you have to take into account, and it happens always in debt restructuring or company restructuring, that you take into account the benefit, what is for the benefit of the entire class, not just your personal benefit. What is for the benefit? So these two principles were the guiding. So we had objections all the way going up to the Supreme Court with regard to it. And third issue, major issue which cropped up and which we are still stuck up with regard to it, is one of the first which happened, insolvency resolution processes happened. I don't remember the name of the company which was there. That it was the promoter itself put in only 5% of the amount of it, and then on the basis of it, there was a lot of hue and cry that the resolution was in favor of the promoter himself, and who was putting in only 5% of the money with regard. So we have got section 29A was hurriedly enacted. And the effect of the enactment of section 29A has been that people think that everyone is willing to put in the money, whatever it is, he will try to save the company. But one aspect which we have also observed is that many people who would have been, I mean, the promoter, of course, you should not allow him if he's a company. But the fact that if my company has failed, okay, I should not be allowed to bid for that particular company. But why should I not be allowed after to bid for another company? By the fact that you have disallowed a person whose company has failed to bid for any other company, what you have essentially done is that you have restricted the amount which the creditors might get. A big category of the creditors who might bid and who might be able to pay a greater proportion to the bidders who might be able to pay a greater proportion to the creditors, they have been disallowed. So these are the few things which I had to observe, which my observation is. Okay, I think I won't take much of your time. Okay, thanks a lot.
I request Mr. Girish Mitre, sir, please give memento to Professor Anil Kumar Rai, sir. And I request Mr. C.S. Sanjeeva Rao, sir. CS Sanjeevara sir to give memento to CS Dr. A.G. Ravindranath sir. Thank you to our esteemed panelists and presenters for sharing their insightful perspectives on the IBC, especially on corporate insolvency and technology and IBC and M&A. So on behalf of the organizers, I extend gratitude to our speakers, audience, everyone. With that, we conclude this session. Thank you.
Thank you. Thank you.
Just a small announcement to the participants. Once the governor enters, no one will be allowed to leave or enter this room. So ensure that you plan accordingly. Thank you. So we've been asked to assemble at 3:30 at the SARC hall. That is this hall. But we will confirm soon, sir.
ఓకే జాయిన్ అయ్యి చెప్తాను టీ జాయిన్ అవుతాను అక్కడ ఉంటారు అందరూ ఓకే హలో
Everyone seated here is requested to proceed for the tea break near the Thinking Man statue. Post that, we'll be starting with the valedictory session.
Check. 1, 2, 3.
Hello. 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 Hello.
Hello. Hello. Hello.
Sir, okay na? Hello.
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 Hello. Hello. Hello.
Hello. Hello. Hello. Hello. 1, 2, 3. Hello.
Hello, check. Hello.
Hello, hello.
Hello, hello.
Hello, check. Hello. Hello, check. Hello.
Hello, mic test.
Hello, check. Hello. Hello, check. Hello. Hello, check. Hello.
Very good afternoon, everybody. Our chief guest, Honorable Governor, sir, will be coming soon. And I request after Governor, sir, enters into the room, there should not be any mobility inside the room or either from outside to inside or inside to outside. There will not be any mobility and nobody will be standing in the room. Unless when the sir comes, we all will stand for the purpose of respect. And when he is speaking, nobody will stand. Please keep that in mind.
Respected dignitaries, members, students, and all the participants, a very good evening to one and all. I'm sure all of you have been overwhelmed with knowledge now after the 2-day session, which is a power-packed sessions on governance, laws, and IBC and many other matters. And I'm sure everyone is ready to use that in, knowledge and the new insights. So we'll be proceeding for a valedictory session now. Just a small request, please keep your phones on silent mode and do not get up during the valedictory session. So our chief guest has already arrived and we'll be starting off the session in another 5 minutes. So I request you all, once he's arrived, I'll inform, and I would request everyone to please stand up. Vice President from Atuar. That's my former. I will have calls to DC sir and the doctor. A small reminder again, please keep your phones on silent mode. And we'll be just starting off our valedictory session now. Our chief guest has arrived and all the dignitaries are coming, so we request everyone to please stand up. We request everyone to please rise for the national anthem.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उत्कल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
Thank you, everyone. We welcome our respected chief guest, Sri Jishnudev Verma sir, Honorable Governor of Telangana, and we would request CSB Narasimhan sir and Professor Sri Krishna Deva Rao sir to please present him a sapling. We request Professor N. Vasanthi ma'am, Registrar of Nalsar University of Law, to please present a sapling to CSB Narasimhan sir, immediate former President, ICSI. We request CSR Venkatramana sir, Council Member, ICSI and Convener CCGRT Hyderabad, to please present a sapling to Professor Sri Krishna Deva Rao sir, Vice Chancellor, Nalsar University of Law. We request Professor Kiran sir to please present a sapling to Professor N. Vasanthi ma'am, Registrar, Nalsar University of Law. We request Professor Sridhar sir to please present a sapling to CSR Venkatramana sir, Council Member, ICSI and Convener, CCGRT Hyderabad. We welcome one and all once again, and we would request Professor Sri Krishna Deva Rao sir, Vice Chancellor of Nalsar University of Law, to please give the welcome address.
I welcome His Excellency Sri Jishnudev Verma ji, Governor of Telangana, Sri CSB Narasimhan, former President of the ICSI, CS Venkatramana, the Council Member, a close friend who is the spirit behind organizing this 2 days national conference, my colleagues, ladies and gentlemen. Nalsar and Indian Institute of Corporate Affairs, New Delhi, have started a very innovative program, LLM in Insolvency and Bankruptcy program in the year 2023. And this master's program, the first year students study here, second year they go to the IICA New Delhi. And when we are trying to look at strengthening this insolvency and bankruptcy, we thought something is missing in the entire corporate restructuring process in India, that is sustainable development, we call as a environment social governance. So therefore, this year, the national conference has selected most topical and contemporary area. Let me on this occasion, I remember a great poem, Telugu poem, which explains about importance of the nature. I thought I'll just share that. And this is Jandyala Papaya Shastri. I think some of you from Telugu speaking 2 states remember him. So let me just, this is a poem about lamenting about the flowers. When someone wants to pluck flowers, how the tree laments. Itna badhiya poetry likha hai. So let me start with that. This was the poem by Jandyala Papaya Shastri, translated by Amba Prasad Rao, narrates about the pain flowers experience when people pluck them. It's deeply touching and makes many people to declare that they won't ever pluck flowers again. The pathos of famous Telugu singer, late Ghantasala, like Bollywood singers like Gurudat, Manmade, Kishore Kumar, Noor Jahan, Talat Muhammad. Similarly, Ghantasala was a great singer. So the song and his voice brings a lump in the throat and tears to everyone's eyes. Let me briefly summarize the poem for you. I thought that would be the better in the valedictory session I could contribute. So it starts. I went to the garden early in the morning to pluck flowers for your puja. Dear God, the garden was sparkling in the morning sun. The young flowers were cutely playing in their mother's laps. Then, standing near a flower plant, I was about to pluck a flower when all the flowers raised a piteous wail. What they said? Would you take our life? They asked me tearfully, and before my mind, eyes flashed this poem called Pushpa Vilapam. Jandyala Papaya Shastri's Lament of the Flowers emerged. In the meantime, God, a jasmine flower said to me in soft voice. What did the jasmine flower say? During our short span of life, we decorate our mother, the creeper that bore and cherished us. Swinging in our arms with gay abandon we play, and when the end comes, we happily fade away. Why do you come in the way of our free life? What did we do to you? We are happy and free. Do not be selfish to pluck us. This is what the jasmine flower is saying when somebody wants to pluck that flower. Do not tear away a child from its parent. The flower further questions me, my God, does your human race have any morality whatsoever? In this way, when the flowers cheated me, I could not pluck any flowers. Not knowing what to do, I came back with empty hands, with just this heartfelt poem, and request you, O God, to be kind to me and forgive me for not offering flowers. I thought it would be better to revisit this poem because we are now at the other end of the spectrum. Leave alone flowers, we are thoughtlessly chopping down huge trees everywhere, breaking down rocks that are millions of years old and endangering various species of birds, insects, and animals. This is what I think the 2 days we are trying to understand: environment, social governance, sustainability, and SDG goals. I think the Indian Company Secretaries of India, Nalsar, and all of us in the corporate, personal life, professional life, let's take a oath that we will never take anything against the environment, and let's look for that we will remember Sundarlal Bahuguna. Chipko movement. Again, we should start that. And this, we should look for expansion and intensification of agriculture and production and consumption, and even how do we increase the contact between wildlife, livestock, pathogens, and people. These are all the several challenges currently we are facing. I'm happy that 2 days national conference attempted to address some of these, but now we have to practice. Thank you. Jai Hind.
Thank you, sir, for the wonderful welcome address to make us realize once again that compliance, environmental laws is not only about compliances, it's more than that. And we hope we'll stand by the oath, what you have said. Thank you so much, sir. Now we request Professor P. Srinivas Subbarao, sir, Head of the Department of Management Studies, Nalsar University, to please present the report of CORP CON 2025. Please, sir.
Respected Chief Guest, His Excellency Sri Jishnudev Varma Sir, Honorable Governor of Telangana, distinguished dignitaries, esteemed guests, faculty, colleagues, and participants. It's my privilege to present the conference report of CORP CON 2025, which was jointly organized by Nalsar University of Law and the Institute of Company Secretaries of India, and held on September 12th and 13th, 2025 at this Sarkla Hall. We received 180 abstracts, of which 68 high-quality papers were selected for presentation across the 2 technical sessions, 24 papers on the ESG, and 44 on the Insolvency and Bankruptcy Code. This reflects the diversity of perspectives from professionals, academicians, and students. The conference commenced with the traditional lamp lighting ceremony led by the Honorable Vice Chancellor, Professor Sri Krishna Deva Roy, joined by the eminent dignitaries. The Vice Chancellor, in his welcome address, emphasized the integration of ESG principles with sustainability and entrepreneurship. CSPS Rao spoke on challenges in mergers, insolvency, and restructuring, highlighting that companies belong to society at large. Mr. Indrajit Shah of CBRE presented the sustainability practices of Tata's, Infosys, and Mahindra, calling for ESG curricula in academia. Mr. C.S. Ranjit Pandey urged corporates to treat ESG not as a mandate but a necessity, linking it with India's Panchamrit scheme. And the chief guest of the inaugural session, Sri Gyaneshwar Kumar Singh, the Director General and CEO of the Indian Institute of Corporate Affairs, affirmed that ESG is integrated into law, corporate law, drawing from Section 166, Section 2 of the Companies Act and the global best practices. He called ESG both a compliance requirement and a existential necessary. When we come to the technical sessions, in the first technical session, we traced the global evaluation of ESG, its link to SDG, and the risks of greenwashing. Papers explored green finance, awareness, and the regulatory role of BRSR. And in the session 2, examined the interplay of ESG and corporate performance, featuring case studies of LIC and SBI, and CSR spending patterns by various companies, and the innovative green pill financing model from Oxford. And the session 3 of the first day focused on regulatory and assurance frameworks with the discussions on disclosure of ESG, disclosure dilemmas, and accountability gaps under SEBI's BRSR regime. In the second day sessions, we carried forward these themes with the students and young researcher contributions, examining issues of green financing regulations, ESG and insolvency frameworks, technological tool for compliance, and legal challenges of greenwashing. The papers underscored the urgent need for standardized taxonomies, digital reporting mechanisms, and incentive-based models to strengthen the ESG implementation. The discussions reflect a blend of academic rigor and practical recommendations, signaling the depth of emerging scholarship in this field. Echoing the dynamism of the legal and corporate landscape captured in today's technical sessions, the conference further spotlighted the growing intersections between the insolvency law and the new dimensions such as digital assets, AI-enabled risk management, and sustainability. Presentations probed challenges in integrating virtual assets within insolvency regimes, the use of AI and data analytics to strengthen resolution process, and a proposal to embed environmental and social responsibilities within the IBC framework. Debate around statutory priorities, procedural reforms, and cross-border complexities reflected a recognition that future corporate law must balance value maximization with the broader social and ecological stewardship. These discussions underscored CORP CON's commitment to fostering research-led, forward-looking solutions for India's evolving corporate environment. And finally, after the 2 sessions of the 2 days discussions and deliberations, we have some takeaways from the CORP CON 2025. The first one is the ESG has moved from voluntary ethics to mandatory governance, making it is a strategic necessity. Second one, transparency and accountability in reporting remain crucial challenge. Third one, green finance and CSR must evolve into impactful and enforceable practices. Digital tools, standardized taxonomies, and stakeholder-driven accountability are essential for the future. The overarching message, profit must align with purpose, embedding ESG not just in compliance, but in corporate culture. For the 2 days, CORP CON 25 has brought together policymakers, regulators, professionals, academicians, and students in meaningful deliberations on ESG and IBC. The 68 papers presented enriched the discourse and offered valuable insights for corporate India's sustainable future. On behalf of the organizing committee, I extend heartfelt gratitude to Nalsar University of Law, ICSI, and all speakers, panelists, paper presenters, and participants for their valuable contributions. With these words, I respectfully present this conference report to the august audience. Thank you, one and all.
Thank you so much, sir, for presenting the report of CORP CON. The 68 papers presented, it is really commendable and understandable, the detailed study done in the topics which have been selected very carefully. So thank you so much, sir, for giving us this opportunity. We would request CSR Venkatramana, sir, Council Member of ICSI and Convener CCGRT Hyderabad, to please address the gathering.
Guru Brahma, Guru Vishnu, Guru Devo Maheshwaraha. Honorable Sri Jishnudev Varma, sir, Governor of Telangana State, our chief guest for the day. Respected Professor Sri Krishnadeva Rao, sir, Honorable Vice Chancellor, Nalsar University. Respected Professor N. Vasanthi, Madam, Nalsar University. Our beloved former President C.S. Narasimhan, sir. Dear members, students, legal professionals, research scholars, and dignitaries of the dais and on the dais. Very good afternoon to you all. Sir, I would take the courage to wish you in your language, Dipo Kaham, sir. On this occasion, friends, I would like to recollect the sloka of Guru Ashtakam, Seriram Surupam Tatava Kalatram, Esescharu Chitram Dhanar Merudalyam, Guru Rangri Padme Manaschena Lagnam Tatakim 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 Tatakim. It means one may have handsome personality and supporting wife, fame spread far and wide, wealth enormous, stable like Mount Meru. But what of the consequence of all this if the mind is not elevated in the devotion lotus feet of Guru? Friends, there are a lot of Gurus are here, so I bow my head to all the Gurus present over here who made me to reach this stage. Friends, today we have 3 distinguished personalities and leaders with us. Honorable Sri Jishnudev Varma, sir, leader of the state, and Sri C.S. Narasimhan, sir, and Professor Sri Krishnadeva Rao, sir, leading the 3 organizations. Our chief guest for the day has sailed from the beautiful state, having rich heritage and culture and ecology. It is the state where the education is free between 6 and 14 in thousands of public primary schools, secondary schools. Dear friends, I request to welcome once again a big round of applause to chief guest, sir. Governor, sir. Sir, we are very delighted to have you here, sir. Sir, the ICSI has very good connectivity and concern about the growth of the people of northeastern states. We have released a publication of ease of doing business in northeastern states. Sir, taking the inspiration from your state, our ICSI council, this council has taken up an initiative for full fee waiver scheme for all the students registering for executive program of CS course and in the northeastern states, Arunachal Pradesh, Assam, Tripura, Manipur, Meghalaya, and all 7 sister states, irrespective of their percentage of marks, sir. And our beloved President Sri Dhananjay Shuklaji and Pawanji Chandak, Vice President, could not grace this occasion as they were attending a conference titled Suryodaya Towards Sustainable Tomorrow today at Guwahati, organized by Guwahati chapter of ICSI, which evidence our priority given for the excellence of professionals in northeastern states. During this year, we have organized National Practicing Company Secretaries Conference at Guwahati on 14th and 15th of June, and Sri Lakshman Prasad Acharya, Honorable Governor of Assam, inaugurated that conference. Friends, our President and Vice President have conveyed their best wishes in their message through the souvenir released yesterday. And I thank the President for giving us the opportunity to organize this program at a national level. Friends, we are delighted to note that our honorable chief guest has came from a royal family of Tripura and from the family of Indian military services. Sir, I am glad to inform you that our ICSA also taken an initiative to give 100% fee waiver for wards and widows of the martyrs of Indian Army, Indian Air Force, Indian Navy, and all paramilitary forces 100% at the time of registration for executive programs. The ICSI has also signed MOUs with universities, institutions for all academic collaborations in northeastern states like ICFI University, Sikkim Manipal University, Apex Professional University, Arunachal University, Assam Don Bosco University, and many other universities. Our institute is also closely working, providing governance and ethical standards, taking forward all industrial promotional initiatives of government of Telangana. In this regard, we would like to, yesterday we had a discussion, sir, the Professor Sir and Director General was there of DOS IACA, and where we have thought of proposing setting up of an incubation center for the startup of MSMEs, jointly by ICSI and Nalsar University. Sir, the roots of the governance in the country starts from the governing villages and Gram Panchayats, and ICSI is the first institute to take this initiative in publishing model governance code for Gram Panchayats. Sir, we are very much admired with your speech given at Khammam, emphasizing that everyone should share the responsibility to protect the environment and nature to ensure healthy atmosphere in both and urban and rural areas. And sir, we would like to also express our gratitude for our wonderful initiative for promoting sustainable livelihoods among particularly vulnerable tribal groups, PVTGs in Telangana, funded through governance discretionary grants, which helps off vehicles carrying machinery for manufacturing eco-friendly leaf plates and cups to tribal villages. On this occasion, I would also like to inform you that there is a need to amend the Telangana Stamp Act and to provide a confirmation that every agreement, every transaction undergoing the stamp duty, attracting the stamp duty must be properly paid the stamp duty, and revenue audits may also be introduced. By leveraging our expertise and fostering the collaboration, ICSA plays a crucial role in supporting the government's vision of strengthening governance, contributing India, and to achieve the Vikshit Bharat 2047, a developed Indian nation, is a visionary concept that envisages a transformed and developed India by 2047. Dear friends, Hope you have enjoyed the pleasant climate and ecology at the Nalsar University premises for last 2 days. I would also love to be a student of Nalsar University in near future. I'm missing that. After spending 2 days of time, I'm realizing that after seeing the effective learning system here. Friends, on this occasion, before closing my address, it is my prime duty to acknowledge and thank Professor Krishnadeva Rao sir, Vice Chancellor, Nalsar University, for giving us the opportunity to jointly organize this program, and for the support and cooperation extended by Professor Kesava Rao sir, who is a Dronacharya of Nalsar University, and Professor Subba Rao sir, our CS member and faculty of Nalsar, Mr. Sridhar, CS Sridhar, and other faculties, Charan sir, Kiran sir, for their meticulous planning and execution on this of this conference, and the students of Nalsar University who volunteered 2 days of the conference, who worked in background 2.5 months, and also our team of ICSI, DVN Sharmaji, Ajay Sharmaji, Mr. Seshu, especially for mobilizing sponsors, and Mr. Narsingh Raju, Mr. Ismail, Ms. Priya, for their continuous effort for past 3 months to make this conference most successful. I thank all the sponsors who has given financial support for this program. I cannot take by name everyone. Last but not the least, all the participants who came from various parts of the country, and participants who also participated through video conference, without whom we cannot spell the success. Sir, once again, I thank you very much. I would like to say, Belekeno Hambai, and Sir Narsimhan sir is our Bhishma Pitamaha. Under his guidance, for 16 years, 15 years in the council, we learned so much, and he is the person instrumental getting the Hyderabad chapter. We are very thankful to you, sir, and we are very happy to have your gracious presence here. Friends, a big round of applause, and thank you very much for all of you. Thank you, one and all. Sir, finally, I would like to take, your, please forgive me. Anona Karjida is the word which you use to seek forgiveness if any wrong words are used in pronunciation of your language. And Jai ICSI, Jai Nalsar, Jai Hind. Thank you very much.
Thank you so much, sir. Thank you, Nalsar University and ICSI once again for arranging such a nice conference and giving us the opportunity to be a part of this conference. Thank you, sir. We would request CSB Narsimhan, sir, former president of ICSI, to please address the gathering.
Good evening, everyone. Chief guest for the day, His Excellency Shri Jishnu Dev Varma, Honorable Governor of Telangana, Professor Sri Krishna Deva Rao, Vice Chancellor, Nalsar University, Professor Srinivas Subba Rao, Department of DOMS, Dancer, Madam Vasanti, Professor of Registrar, Nalsar University, my colleague in the council, the little dynamite, Mr. Venkatramana, and all the participants over here. In a valedictory session, it's generally a purpose of to reminisce what's happened during those last 2 days, to identify what the key takeaway from whatever has happened, whatever we learned today. And I think that was wonderfully summarized by Srinivas Subba Rao. My connection with the Honorable Chief Guest was when we got to meet in Hyderabad in one of the programs of the Institute last year, when I was the president of the Institute, and that was the regional PCS conference which was held in Hyderabad. I mean, he delivered a wonderful address, and I do recall bits and pieces of what he said. But it is a key, I mean, it was a wonderful, for me, it was a wonderful experience itself. As far as Krishna Deva Rao is concerned, I can tell you, I was instrumental in getting in this MOU signed in Hyderabad when I came over for the purpose for a meeting, and then we got to get this quickly signed. I was in a tearing hurry to catch the flight. We got it done, and then last year again. This is not the first one. We had one program last year as well on CORP CON, and that was also, I got to meet him again. So I'm very happy to be around here. And let me tell you, despite the fact that Mr. Subbarao has already summarized every aspect of what has been discussed during the last 2 days, but I thought I should share my own take on what ESG is all about. I think what we need to look at is for the future. You cannot be so selfish that you degrade the environment to such an extent the future does not exist. So we have to be extremely careful in whatever we do. Every single bit of activity which we do, including the poem of Ghantashala about the flower, it's very meaningful one. But all said and done, the flowers are collected for being offered to the Lord, and I'm sure the Lord will take care of it in getting the flowers there again. So this is the first thing we need to know, and it has taken center stage now across the world. You know, it is the ESG has taken the center stage, and again, as far as India, we are no exception. We had what is known as, what started off maybe in early 90s or late 80s as what is known as the triple P bottom line: people, planet, and profit. And that's now turned into BRSR. So in 2012, we had SEBI coming out with what is known as BRR, Business Responsibility Reporting. So that was what the starting point as far as India was concerned, as far as this is concerned. But then SEBI realized that it's not only the business responsibility, it's also to be sustainable one in whatever they do. And therefore, it was converted as BRSR. And that started off. And what was shared by Mr. Subbarao is a bit worrisome, because he did say that in his identification of various BRSR reports being submitted by various corporates, he finds quite a few control V, control C. So that is where the concern starts. And I think we need to look at that should not be. And SEBI is already looking at it. Let me tell you, in my discussion, because I've been closely working with the regulator, and in my discussion with the regulator, they are looking at doing an impact assessment. So there was SEBI, in fact, liberalized a bit. In fact, they wanted the downstream and upstream also to be covered 75%. But then some of the large corporates found it very difficult to enforce that kind of this thing on their vendors. And therefore, SEBI took back. The board considered the views of the suggestion which was made. They took it back. But sooner or later, we need to realize that it has to come from all. Each one of us has to contribute in some whatever manner we can. So this SEBI is already looking at what is known as impact assessment. So whatever is being done, does it realize the purpose for which it was done? So that is going to be very important, and they may look at professionals like us to possibly do some kind of a certification so that there's some comfort in whatever is being done. Well, the other topic is on insolvency. I think many of our members there's become a bread and butter for them. They are very well versed in what's being done, and taking cognizance of the importance of NCLT. The government has also already increased the number of benches in several cities. It has increased the number of benches across the country. Not only that, it has also opened up new benches in some of the cities. So this is a very important, very good initiative by the government, and I'm sure all of this will augur well for early resolution of the insolvency cases which are pending. Lastly, but not the least, my little friend over here, my counsel and the colleague, with the permission of the chief guest, I want to say a few words about him. He is a pocket dynamite. There's a saying, Kirti bahut chota hai, Murti badi choti hai, but Kirti bahut badi hai. So that is what he is. And I admire the kind of the kind of where he gets this energy in terms of getting it done. And once he decides he wants it, he gets to do it. And I'm sure you would, Mr. Krishna Nalsar, Vice Chancellor, also seen it, bought last year as well as this year. He has been running around, and I think he deserves a round of applause from each one of you seated over here. whatever little key takeaways you're going to have from today is a major contribution from that little guy over there. Thanks a lot for the opportunity given to me. My apologies. My president and vice president could not be here. They had prior commitments. They are currently in Guwahati. Mr. Venkatramana has already explained that. I'm very happy to be here, and maybe another occasion I'll be possibly one of the faculty sharing my thoughts with you. Thank you very much.
Thank you so much, sir. Thank you very much. And as you have said, rightly said, ESG is a very important aspect in today's day, and it has been wonderfully explained in the two-day conference. One small thing which I would like to say for VC sir is we will remember the poem whenever we are plucking flowers. So we'll follow giving back to the society. Thank you so much, sir. So now we are coming to the icing on the cake. We request our respected chief guest, Sri Jishnu Dev Verma sir, Honorable Governor of Telangana. We would first thank him for gracing this occasion, and we request him to please address the gathering. Thank you so much, sir. Please, sir. And we welcome him with a huge round of applause.
Namaskar. Professor Sri Krishna Deva Rao, Vice Chancellor, Nalsar University of Law, Sri CSB Narasimhan, immediate former President, the ICSI, CS Venkatramana, Council Member, the ICSI, and Convener, CCGRT, Hyderabad, Professor N. Vasanti, Registrar of Nalsar University of Law, distinguished guests, esteemed academicians, professionals, and my dear students. I'm delighted to stand before you today at the valedictory session of CORP CON 2025. This conference, hosted by two eminent institutions, Nalsar and ICSI, is more than an academic gathering. It is a crucible where ideas, laws, ethics, and enterprise come together to shape the future of India's corporate governance. I'm reminded here of the words of Mahatma Gandhi: the future depends on what we do in the present. The deliberations that you have had over the past days are not just scholarly exercises, they are seeds of ethical and sustainable corporate practices that will shape India's tomorrow. Today, we reflect upon two crucial themes: environmental, social, and governance practices, and the Insolvency and Bankruptcy Code, IBC. These are not just regulatory frameworks, but moral compasses that guide the corporate ecosystem. Hyderabad, the venue of the conference, provides the perfect backdrop. This city, with a seamless blend of history and innovation, symbolizes transformation. As Rabindranath Tagore once wrote, the highest education, that which does not merely give us information, but makes our life in harmony with all our existence. The ESG is exactly this, bringing harmony between enterprise, environment, and society. As Albert Einstein said, try not to become a person of success, but rather try to become a person of value. In the corporate context, ECG asked us whether our success creates value for society, for the environment, and for future generations. It is not an important idea, but deeply rooted in India's civilizational ethos of Vasudhaiva Kutumbakam. The world is one family. The Insolvency and Bankruptcy Code 2016 has been one of India's landmark reforms. By consolidating fragmented laws into a time-bound resolution framework, it has brought greater certainty, restored creditor confidence, and ensured accountability. As Sardar Vallabhbhai Patel reminded us, every citizen of India must remember that he is an Indian, that he has every right in this country, but with certain duties. In the same spirit, corporate citizens too have duties towards fairness, transparency, and sustainability. To the students here, I say this: you are the torchbearers of India's corporate future. whether in law, finance, or governance, carry with you the values of integrity, innovation, and inclusivity. Once, our former president, Dr. APJ Abdul Kalam, reminded us, dream, dream, dream. Dreams transform into thoughts, and thoughts results in action. May your dreams be guided by ethics and your action by wisdom. And the great saint Swami Vivekananda added, take one idea, make that one idea your life. Think of it, dream of it, live on that idea. This is the way to success. Let the idea be ethical and inclusive growth. And I was listening to the poem that was translated in English from Telugu by the Vice Chancellor, and I found it very, very touching. I am very fond of poetry. And the lamentation of the jasmine flower, it is a symbolic representation of how we use our natural resources without any empathy. It symbolizes that plucking of the flower symbolizes how we indiscreetly use our natural resources, thinking they will last forever, and that we are, the owners. We think we are the owners. We are not the owners of anything on earth. We are here to share everything on earth. That's what our Indian way of thinking has taught us. And I come from the Northeast, and as he was saying in my language, he said a very nice word in my language, hambai. It's a very nice thing. It's it's an indigenous language. It means, goodbye. It means welcome. It means good day. It means see you again. It's something like an Italian ciao. It means everything. So these tribal societies of the Northeast are very, there's something to learn from their societies and the way of living. We're always trying to teach them. We're always trying to teach them what modernity is. I remember when I was young, and we used to have the school debates, and we used to debate, till the cows came home, whether it was development or it should be, environment. Some of us would say, development, it means money, it means, progress. What is this? No, not cutting trees and sitting, looking at rivers and the skies. But today, the whole picture has changed. Today, we have understood that without sustainability, development means very little. Because we have to look at the future. And the tribal societies, whom we call the primitive societies, have understood this. In Meghalaya, one of the states of Northeast, you will find sacred groves, where each tree is a deity, and they pray to each tree. I remember many years back, I was very young, and we have 19 tribes in Tripura. We have 19 indigenous tribes in Tripura, and each one has its own, textile designs. In a small state, 19 tribes, and each tribe, very small tribes, having their own motifs and designs on textiles. And I was very fond of, designing those days. It was the in thing when we were young. So I would look at the designs and I said, well, let me write a book on these, tribal textiles of Tripura. And I started traveling all through the villages, and I could see all the designs and all these motifs, as they called, were all, inspired by nature. Whether they were trees or flowers or animals which were found in Tripura. And I used to travel extensively. And one day I met a very old man. He was the headman of the village. There we have headmen, who look after the village and who, sort out the differences, like a magistrate. And he is revered by a whole society. He is known as the Gaon Bura, or the elder of the village. So I was speaking to him, and he told me, do you know one thing? Who's the first weaver? I said, no, I don't know who's the first weaver. So I'll tell you, in our legend, the first weaver is the spider. From the spider, we learned we saw the spider weaving its cobweb or its web. And from that spider, we learned how to weave. I will say, narrating this thing because, these indigenous societies looked into things, did not only look at things. And we in the modern society have a habit of looking at things. We don't want to look into things. We want to look at things. And we are very comfortable with our, status quo. Actually, change is not so frightening, but the idea of change is frightening. That is the problem. But these indigenous tribes and these so-called primitive people looked into things. They saw the spider weave. They picked up, designs and very lovely designs from the nature. Nature inspired them. Now we only look at a tree. And we know what we learned in biology or in natural sciences, it takes carbon dioxide, gives off oxygen. That's what we say, but we don't feel it. But we don't feel it. When we look at a tree, we don't feel that it is one of our saviors. It gives, takes in carbon dioxide, gives oxygen. We know it, but we don't feel it. When you look at a river, we don't feel that, yes, this is the, something that sustains our life. We will give a big lecture on it, and very impressive lectures, but we don't feel it. So that poem the Vice Chancellor read is a feeling. You feel that you're plucking something. You feel you're taking something from nature. And when we take something, should we not give back? If we are not the owners, we are not the owners of nature, should we not give back? Should it not be out of, should it be out of need, or should it be out of greed? These things are to be answered, to be felt. Knowing we know everything, half our lives are now spent on the screen. We're tapping on our phones and finding out everything. We know so many things, but we feel very little. We know so many things. We are walking encyclopedias now. And if you don't know, you can know. You can just search for it on Google, you'll know. Sometimes you may know the wrong thing also, but you'll know. But that screen doesn't teach you how to feel. That screen does not teach you, Google search does not teach you how to feel. Like the tribal man felt, yes, he's the first weaver, the spider. Who got inspired by nature and wove the designs into their textiles. He was inspired by something. Nowadays, nothing inspires us. We know too much, and we feel too little. So as we have these conferences, it is important to feel, to share knowledge. And I always tell students, classrooms are very important and you must learn from classrooms, but what you learn outside classroom is even more important. That's where you learn friendship, that's where you learn compassion, that's where you learn empathy, that's where you learn how to live in a community. The tribals of my region, even till now, even with the advent of so much of modernity and so much of iPhones and phones and tablets, they still think that these resources are community resources. They don't say it is mine. They are still hunting taboos. You cannot hunt anything you feel like or hunt when you feel like. Because they have realized that nature supports us and we must support nature. It is a symbiotic relationship. It is not a one-way relationship. It is not an exploitative relationship. If you exploit, you will be exploited. That's why we are having climate change and flash floods and whatnot we are having. When you exploit, you will be exploited. When you give compassion, you will get compassion. So I'm very happy that the students are here, teachers are here, and the organizers have done a very good job. I have been to one of the earlier functions also. It was very nice, and they did a lot for Northeast, and now also they are doing for service personnel. There's a sense of value in what they do. That is a good thing. Not only with a sense of putting out a thesis or putting out a seminar paper. So let us do something with purpose. And when we do it with purpose, we begin to feel. We think and we feel also. So I wish that this conference will bring out something very positive, will make you think, make you feel, make you learn, and make you unlearn so many things also. In the process of unlearning has become important nowadays. And I must congratulate the organizers and Nalsar for this conference. And I'm happy that I've been able to come here and speak to you all. Thank you so much. Jai Hind, Jai Bharat.
Thank you, sir. Thank you so much. Thank you from the bottom of our heart for giving your precious time and making this conference a huge success. It is said that all's well that ends well. And what can be better than hearing the words of our Honorable Governor, who himself is a man of refined talents, poetry, and literature. Thank you so much, sir. However, the conference is a beginning or it's a journey towards better practices. So we would like to felicitate our respected chief guest as a small token of gratitude. We request CSR Venkatramana sir and CS B. Narasimhan sir to please present a shawl to our respected chief guest. And we request Professor Sri Krishna Deva Rao sir to please present a memento to our Honorable Governor. So, we are grateful for all the dignitaries on the dais and off the dais for gracing this occasion today, and we would request Professor Sri Krishna Deva Rao sir to please present a shawl to CS B. Narasimhan sir. Please, sir. And we request Professor N. Vasanthi ma'am to please present a memento to CS B. Narasimhan sir. Memento. The conference has been a huge success under the guidance of ICSI and Nalsar, and we would request CSB Narasimhan sir and CSR Venkatramana sir to please present a shawl to Professor Sri Krishna Deva Rao sir. Please, sir. We would request Professor N. Vasanthi ma'am, Registrar of Nalsar University of Law, to please present the vote of thanks. Please, ma'am.
Good evening, everyone. I have the privilege and the pleasure of offering the vote of thanks to a conference that has really raised very important questions for all of us. So it's very nice to see the Institute of Company Secretaries and our own Center for Corporate Law and Competition Law in the Department of Management for very successfully organizing this conference. Let me begin the vote of thanks by offering a vote of thanks to our distinguished chief guest, Sri Jishnudev Verma, the Governor of Telangana, for his gracious presence and very inspiring words. Sir, I will never forget this distinction that you made between looking into and looking at. And it has really set off a thought within our mind, and I'm sure for everyone here, as to the significance of the ESG with reference to corporate governance. And I think that is where the future is. So thank you so much, sir, for your really insightful words that we will all carry with us. Let me also thank the Institute of Company Secretaries for taking this initiative and organizing this conference with us to highlight and invite a lot of speakers to think deeply about and write about an issue which is of great significance to all of us. So let me thank the organizer, Sri Venkataramana, for all his efforts in all of these months to put this together, and the gracious presence of B. Narasimhan for the valedictory session. But a conference is also about all the panelists and the dignitaries who have graced the occasion for 2 days. So let me thank all the panelists, the dignitaries in the inaugural as well as the valedictory session, the participants for taking time out and participating in this conference. As the chief guest has already pointed out, conferences are not only about writing papers, but also the interaction between participants and the sharing of knowledge that will set off further thought in all our mind, and we will work towards innovation in this area, which is such a critical area. I'd also like to thank Professor Keshav Rao for all his efforts despite his ill health, for taking time off and wholeheartedly involving himself in organizing this conference. It would not have been possible without your efforts, sir. Thank you so much for all your efforts. I would also like to thank the head of the Department of Management Studies, as well as the organizers, whether it is Charan or it is Sridhar or it is Kiran, who have worked tirelessly, even despite their own ill health, in putting this conference together, and a big vote of thanks to all of them. The conference usually is about participants and panelists, but there is a lot of support staff who are involved and who are behind the scenes and working behind the scenes to make this conference successful. So I would like to thank all the support staff, the press, our student volunteers, and the entire team of Nalsar, ICSI, as well as the Center for Corporate Law for organizing this conference. Thank you all so much, and I wish you all a very good day.
Thank you so much, ma'am. Thank you so much. And thank you to our registrar, ma'am, for her support. Thank you so much. We would now request everyone to please rise for the national anthem.
हिमाचल यमुना गंगा उत्कल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय 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 हे